Please, my lord. My lord, here, my lord, the petitioner.
First of all, that you have not submitted the, now you are submitting in the court. You are not submitting the
my
transcription.
lord, I have submitted, but that has been lost. So I have given another
Even you have not removed the defects.
copy. Copy already, my lord, I have served.
Mr. Panda, who lost it?
My lord,
Who lost it?
office. I have also given in the office, but that has been lost. For that reason, it is better that it could tender here in the court.
What is the meaning of cattle friend?
Sir,
What is the meaning
Gomitra friend. Gomitra friend. They have stated that is
translation of
Gomitra.
Gomitra friend is the cattle friend.
Better friend is.
Huh?
Sir.
No wonder office lost it.
That is the reason why the office has lost it.
National Cattle and Buffalo.
Basing on, my lord, the criteria that I have fulfilled all the criteria. They have only stated
Insemination. It was insemination. Yes.
my lord, as per the criteria, I have fulfilled all the criteria because I was a science graduate. They have only stated that the one science graduate is required, and I am one of the science graduate and fulfill all the criteria that I have got the experience and my lord.
Yes, come to the learned single judgment over that issue.
My lord, the Lord and Single just said that
where is their judgment?
Judgment, my lord,
10.
page annexure 10, my lord, page 34, page 34, sir.
Come to the relevant paragraph.
My lord. Having heard para 6, my lord, para 6. Having heard the London Council for the parties and after going through the records, this court finds that an advertisement was issued in Annexure 7, inviting applications from the eligible candidate to participate in the process of selection for the post of livestock inspector.
You still come to the paragraph 6, the last part.
Sir. Therefore, the diploma certificate.
No, not for these. Therefore, the diploma certificate in electrical wing obtained by the petitioner
cannot be considered as the equivalent to the +2 science for selection of the post of livestock inspector.
Yes.
More so, the petitioner had earlier approached the tribunal by filing the OA number so and so, which was also disposed of by tribunal by the order dated 17/2/2014, directing the authority to consider the case of the petitioner and pass the necessary order. In compliance of the said order, the grievance of the petitioner has been considered and rejected by the authority. Thereby, by the self-same relief, the petitioner again cannot approach the tribunal challenging the order dated 2/1/2017 passed by the authority by the Annexure 13. In the above view, the matter, this court is also of the considered view that since the post of the livestock inspector is a post which require, this is the relevant, which require scientific treatment of animals due to adoption of the modern technology in the field of animal gentries, question of giving equivalent treatment to the certificate obtained by the petitioner in the diploma in electric engineering does not arise for such appointment.
What is the wrong in that order?
Please see the advertisement, sir.
First of all, issue is very simple. Whether the court is empowered to declare the equivalence of the degrees of this diploma.
Yes.
Court is not.
Yes.
Right? We are not the authority. Despite the learned single judge is going beyond that limit and also given some reasons why this cannot be treated as equivalent.
My lord.
Where is the court? Time and again you are talking. There is no case because whether a diploma certificate can be treated as equivalent to the +2 stage.
But the advertisements are very clear that the only science candidate can apply. That is the advertisement. Please see the advertisement.
We have seen. You have given
there is no category saying that the other was required. Only science. I was the science student.
Read that part. Read that part of this eligibility. Just come to that part.
Sir,
Yes.
Can it be taken up, sir, next week? I will satisfy.
No. Sorry. No next week's business in this matter. Come straight.
My lord,
Number one, you have not fulfilled. Passed in +2 examination with the dairy or animal husbandry. So the primary requisite is the.
I was science graduate. Primary requirement is a science. I was the science qualified candidate.
Mr. Panda, you can go arguing. Come to this eligibility one.
Sir.
Do you have +2 in animal husbandry?
No, no, not +2 in
Then
animal.
your translation, English translation is incorrect.
This is only the basic qualification. You must be a +2 in science,
Sir,
and that you don't have. Heard Mr. N. Pandalan and counsel appearing for the petitioner. By means of this intercourt appeal, the order dated 26/10/2022, delivered in WPC OSC number 1710 of 2017 has been challenged on the ground that the finding of the single judge as recorded in para 6 of the said judgment are not tenable. Stop. It is an admitted position of fact that the appellant doesn't have the qualification of HS within bracket +2 stays, which is the essential qualification for meeting the eligibility criterion. Stop. The petitioner had approached the state administrative tribunal, and it has been, and the educational tribunal directed the authorities to examine that aspect of the matter, and on due consideration, the claim of the petitioner was rejected. So thereafter, again, the petitioner, appellant approached the state administrative tribunal for the same cause, which was rejected on the ground that the petitioner is not entitled to approach the tribunal time and again on the same issue or subject matter. The order of the tribunal was challenged before the learned single judge, who has refused to interfere with the order of the state tribunal by the impugned order. We do not find any infirmity in the order of the learned single judge, and accordingly this appeal stands dismissed. Mr. M.K. Kuntial, under additional government advocate, is appeared for the respondents.
Item 2.
May I please, my lords. Because there's a delay that is there's a condemnation of delay petition that is filed, but the SR says there is no delay because of the corona period. The 157 days delay limitation petition is filed.
No, what is the report? Stamp report?
Stamp report says that there is no delay.
Right.
Fine.
Mr. Dina, an additional government advocate. Stamp report, there is no delay. Application, and accordingly the same is disposed of. Stop. Would you move today the appeal?
The review
Or some
petition, my lords.
Some other day.
My lords, if my lords, it's convenient to my lords, I'll move it to
Review petition.
my lords. If it's convenient to my lords, I'll move it.
Some other day better you
My
do it. List on 10th of July. List the review petition only, list on the 10th of July. Mr. D. Naik, additional government advocate, is appeared for the review petition. Next.
Item 3.
Is here for the Punjab National Bank.
yes.
But this appeal is against the order dated.
We are on caveat.
Mr. Rao, what
Yes,
will happen? Your appeal is barred by 2 days delay.
That delay was condoned, my lord.
Delay has been condoned.
Yes, yes, right. On 3/3/23, It was
Just a minute,
confirmed.
let me check 3-3 order.
Then filing the application. That's right.
3-3 order is not there.
Yes. it- Page 3. Second order.
Oh, yes, delay. Yes. All right, yes. So have you received the?
We have
copy?
not been served with,
Supply
I
the
mean,
copy of
4.
the, it's in
Yes, ma'am.
case
I
of
will submit.
caveat. So we'll discharge the caveat only, you also supply a copy, otherwise the caveat to be.
Yes.
So we'll take up the matter some other day.
Yes, sir.
Short
Caveat
date
number
may be-
3 of 2023. Since Mr. A. Parijal and Senate Council is
And
stated.
Mr.
I
there are
mean
two
item
matters,
4.
but we are in different matters.
Item 4 also same order.
Item 4 also same.
Same.
Already.
So I'm in
Who
4.
is assisting you in this matter?
3, there are 2 matters. That audit petition is still pending.
No, for the caveator who are just appearing.
He's with Mr. Anupam Das.
Anupam Das, madam, for both
Suggested
of
by
us.
Mr. Anupam Das. Has appeared for the caveator. Mr. Rao is assisting you?
Milas.
Who is assisting you?
Mr. Ajit Mahapatra. Ajit Mahapatra. Mr. Ajit Mahapatra.
Mr. R. Mohanty,
A Mahapatra.
A. Mahapatra.
Well, I
Current-
am appearing
current
for the
counsel,
RP. one.
Appearing for the review this appellant has supplied a copy of the memorandum of appeal to Mr. Das, and counsel for the caveator. And as such, we deem the notices served as the caveat is discharged. We'll take up the matter some other day because.
But
of-
I am in difficulty. I told your lordship
Ah.
yesterday till 18th, my lord. So anytime
18th.
thereafter, 18th.
Huh?
3rd August.
3rd August is all right.
Fair enough.
Any urgency in the matter?
There is some urgency because
Pending for so long, so
huge amount has been withheld. And
anytime after 20th, my lord, it's all right for us.
So you suggest because he has some difficulties and other matters also showing some difficulty. Better we fixed on 3rd of August. And with the observation that no accommodation will be
No,
made.
not, we will not.
And we'll decide the matter at this stage only.
Correct, no issue.
Right? Oh, no, they are requesting the appeal.
Appeal only. 2.
So you are appealing for
In
the?
4. In 4, I am appearing
No, no,
along
that-
with
First one, there are 2 respondents.
No, I think you are representing the respondent.
Yes, yes.
First one, there are 2 respondents.
So in item 4, I am for visa infrastructure R1. With us also, the copies have not been served. So they may be served on Miss Supriya Patra, the instructing counsel.
Okay.
And so-
The same thing, we'll be
Same.
working on the first,
Same.
you are appealing for, I think they're both the respondents.
Yes.
Yes.
Right. As agreed by the council for the parties in this appeal.
He's not appealing, Mr. Parijal or Mr. Das.
I understood that. Council for the parties, let the matter be listed on 3rd of August 2023. Only the name of the Mr. Parija and the council will be recorded, the earlier petition. So there shall be no accommodation. This appeal will be heard on merit on the next date. All right. The next case, your case is Mr. Mishra,
Is item number 4. Same orders, same grounds.
just change, who is assisting you?
Miss Supriya Patra. She is online.
She is not here today.
She's online. She's
Oh.
some difficulty, so she's appearing on.
Just caveat the same way, supply the copy to her. And the same
Maybe
order,
request
same-
that the copies be served within 7 days so that we
No,
can.
no. In the course of the day also,
Well,
when I say the
we are
serve,
great.
in the course of the day, copies be served. And so this same caveat order and then also the same order, we'll be fixing on 3rd.
Lordship, please.
Yes.
We are all great.
Item 6.
I may kindly permitted, my lord.
Yes.
I missed my 5. Item 5.
Yes. May I please, ma'am?
Yes.
Well, in this case, the appellants are the assistant professors
Just a
working in
minute,
different
Mr.
colleges.
Chuli,
My lord,
there are a lot of defects.
Lafayette, it's
That is the. No, this item, so 4,
Item 5.
have you checked up the defects?
I have sought the copy. Oh, I didn't know.
Just a minute, I'm telling you.
My lord,
Other side, have you served a copy?
yes,
When?
I have sought the copy on 10th March.
Okay,
Stamp reporting on 31st. No receipt filed probably.
you have not filed the receipt to the registry.
I received.
I
have
don't think
sought the
so.
copy.
Only the
I
copy.
No, no, it's all right.
Copy,
Yes,
sir.
yes. Copies.
Mr.
Dr. Churi.
Dr. P. Chuli, learned counsel appearing for the appellant has submitted that copy was served. And the receipt was not deposited in the registry. Stuff. Mr. M. K. Kuntiya, learned election government advocate appearing for the correspondence has submitted that they have received the copy, therefore the defect stands removed. Yes,
My lord,
now in this main appeal.
may I
Yes.
please? But the appellants are the assistant professors working in different government colleges of Odisha. Since their past services have not been counted from the date of their initial joining, they have approached this honorable court. And this honorable court has directed the authority to consider their representation for the purpose of counting of their past service.
Yes,
But the authority summarily rejected the representation of the claim of the petitioners. So again, the appellants as the petitioners, they have approached this honorable court for getting relief. So after the filing or during the pendency of this the second round of litigation, the writ petition, they have made an executive order or notification that the petitioners or the appellants past services will be counted at the rate of 1 year is to 3 years of their past service. So the petitioners filed amendment petition incorporating that notification, challenging that notification.
you will come, you read para 5 of the impugned judgment.
My lord. I have the input.
And what about this notification dated 9/4/2021?
Yes, my lord. This was the discriminatory. My humble submission is that the several, even hundreds of the predecessors of the similarly situated lecturers, even ad hoc lecturers, their services have been counted from the date of their initial joining. But here the discrimination is that our services have been counted from the date of initial joining, but the amount is to be adjusted, or our counting past services will be counted at the rate of 1 year is to 3 years. That means for 3 years, we will get only benefit of 1 year and not more than that. This is the lacuna, this is the
No, come to the paragraph 5 of the judgment.
My lord. My lord. When Mr. Chuli, I have been here made scapegoat, my lord. Here, Mr. Chuli, learned counsel appearing for the petition is called upon to show cause so as to which paragraph of the rejoinder affidavit contains the answer to the averments made in paragraph 7 of the counter affidavit. He is unable to show it. Therefore, it is deemed that the contentions raised in the counter affidavit have been admitted. This is, my lord, I was just within 2 minutes this it has been disputed. I was just I have challenged that order.
Jet age, Mr. Counsel, try to understand.
My lord.
I am living in an old age because I am granting a lot of spaces to the council. That doesn't mean that will be the rule. Rule should be the jet age rule.
my lord.
You can answer right now or you are perished. That is the rule.
Hey, I have my.
What is your, anyway, what is your reply in the, you cannot show
Yes,
already.
yes,
Have
the
you filed
reply-
in the rejoinder? Have you dealt that issue?
Yes, I have. I have.
what will
Okay,
be the-
okay, show that paragraph
Yes,
now.
paragraph 2, I'm showing, sir, by rejoinder, my lord,
Yes.
at page. Your lordship kindly have at page 280,
Copy of constitution.
280, my rejoinder.
1 to 40.
279, it starts from, my rejoinder starts from 279, and paragraph 2 is 279 and continues, and I am really, my first conclusion is that since similarly situated a person,
Short the
that
bullseye.
paragraph.
Short the bullseye, only come to the relevant points, not to go to the any. So long
But-
preface will not help you.
13, man.
40-page rejoinder. So which paragraph?
That is paragraph 13, my lord.
You
I
said
have-
2 now you're saying 13.
Paragraph 13, my lord, it is 299. May I permit it?
Read. Yes.
That in reply to the statements made in paragraph 6 of the counter affidavit filed by the opposite party, it is humbly submitted.
No,
that
no,
the
you just, in response to the paragraph 7,
My lord,
what is your rejoinder?
my lord, they have, my humble submission is that the state has made a false argument. that
Where have you
yes,
stated so?
You have missed it.
Come to that part.
Yes, this, they have told that.
Paragraph
Not
7.
your oral submission, you want to see the abovements. Mr. Chuli, just appreciate the court position.
Exactly.
Mr. Chuli, we are examining the order of the honorable single judge.
My lord,
So how is the order wrong? So where have you replied to paragraph 7 of the counter affidavit?
I have in reply to the para 6 and exact para 6, I am.
You
I
have
explained.
not, that is the learned single judge's observation,
My-
that you have not taken care of the paragraph 7. So it should be deemed that you are admitting their position.
Well,
No, you show that you have answered to the paragraph 7.
We are going slowly, but you show us.
my humble submission is that since I have challenged that,
Preface less, come to the abovement first.
my lord,
Where have you dealt with that issue? The state government has taken a very categorical stand
my lord,
that your grievance has been taken by the notification dated of the 9th April 2021.
my humble submission is that they have not taken into consideration or they have not given the benefit as they claim that the relief short has been claim. My humble submission is that the difference is that.
Submission.
And you have not challenged that notification also.
Yes, I have challenged.
Where? In the
No,
writ petition.
the-
Come to the relief part.
The
Yes.
rejoinder.
Really, in read petition,
Prayer.
next to 23 mile.
Prayer.
23.
Prayer. Petition is that type.
Direction 1.
Page 271 mile.
No, writ petition.
Read petition,
Yes.
prayer.
Yes, read petition. Yes, in the
Prayer
prayer
must
also
be in the
there.
writ petition. Where the will search for the prayer.
There is also in the prayer. My lord, it is B3 was the order number 22/6/2020 issued by the such and such, and then under answer 19, and then notification
Yes.
dated 16774 of HE dated
No, it's
9/4/2021.
yes. Annexure
Under
23 you have
annexure
challenged.
23.
Okay.
Even this has been reflected in the my lord's order.
We are admitting this appeal.
My lord.
We are admitting this appeal. There is cannot be deemed when this
Yes.
notification has been challenged in the writ petition.
Yes, ma'am. That I have also seen that.
Yes.
My lord.
You should have shown this first.
Obliged, my lord.
Dr. P.
I am a junior advocate.
You are a junior advocate, you are a doctor. Doctorate in what is your subject for the doctorate? Mr. Chuli?
Doctor is my subject is
Law or something else?
related to law, protection of women's domestic violence and the
Order
role of the
dated-
High Court of Orissa.
Order dated 13 to 2023,
Obliged.
delivered in WPC number 17345 up to 2020 by the learned single judge. Stop. We have read the reasons provided in para 4 and 5 of the said judgment. Stop. In the writ petition, the notification dated 9/4/2021 has been challenged. Therefore, we think this appeal is required to be heard on merit, admit, issue notice, since Mr. M.K. Kuntial, an additional government advocate, appears and waives notice for the respondent. No formal notice is called for. Notice is made returnable on 23rd of August, 24th August 2023.
My lord, only one party, only my your lordship may direct me to give extra copy to only one party is there.
We have not asked anything. We are making submission unnecessarily. We have said no notice is called for. Do you need any further copy? I don't think so.
Not in this.
The registry shall place the records of WPC number 17345 of 2020.
There.
All right.
Obliged.
Item 6.
I may kindly permit it, my lord.
Yes.
Six, my lords.
You are for the respondent, who is for the appellant? You are appearing for
I
the
am
respondent.
appearing for the appellant, my lord.
For the respondent, I am praying for. I've taken time, else additional affidavit and find some documents been given. I've not get much detailed information. I expected getting it, my lords, by Friday, my lords. Pre-mails may taken up next week, any day, my lords, be convenient. Because the
My-
auction is fixed to 26th.
Oh, we'll fix the matter on 10th of July, Mr. Tripathi.
My lord,
10th of July this
Yes.
month.
10th of July, I will do it, my lords.
my lord, it may kindly be on the 11th.
Hello?
11.
On 10th, I am to appear in.
He wants on 11th.
discharge in the
11th of July, you want?
11th.
Okay.
My lord, in the meantime, my humble submission is that during the pendency of the writ application, the counter affidavit was filed after 11 years. And during pendency of this writ appeal also, on the last occasion, your lordship had the junior advocate.
Whether the writ appeal, this counter affidavit filed by this leave of this court or straightway it has been filed?
Counter affidavit, they filed in the original writ
No,
application.
no, that was
Or
the
writ petition,
Writ
that's all
petition.
right.
Writ petition.
We are now in the
My
writ.
lord, in the
Yes, my
on the
lords.
last occasion,
delaying
your
of the
lordships
time,
directed that
noticing.
today will be the last opportunity for both the parties. So both the parties will make all, your lordship may kindly have the,
Well, sir,
have a glance to that
21st
order. And last date, on the last date, it was made very clear that all efforts will be made to
Yes,
dispose
yes,
of
yes,
the today,
yes.
hear the matter today. Because 27th July is the last date for auction of the plot. My lord, my humble submission, let there be an interim stay. Let
But
there be
sir,
an interim stay
20
not to dispose of the plot.
Just a minute.
Let,
On
then thereafter, let them
21st
take as much time as they like.
Just a minute. On 21st/6/2023, they filed an additional affidavit enclosing number of documents. That is what I've sent them for detailed clarification. Because
That
of my
documents
illness
my lord are
also, I could
obtained
not
from
pursue
CA
them.
itself.
Just a
It
minute.
is their document,
Just
not
a
that I have
minute, please,
created.
just a minute. Because of my
Anyway,
illness
now
also.
we're passing the fixing the matter 11th, and we just blanket order will be plus there will be no accommodation on the next, we hear the matter. on
Yes, yes,
merit.
I, because of my, I couldn't do that.
So let,
Because of my illness, I could not pursue them.
Now,
Otherwise,
that
I
is
could
why
have
we
done.
are accommodating you 11th by
11th
11th.
minus, I would be doing it positively, minus.
By, no, not 11th. By 7th of July, you have to file the affidavit or other
7th
whatever.
of July, my lord.
27th
By
July,
10th.
7th July,
27th July, this month 27th.
7th of July, my lord says.
You
what?
have to file
No.
your affidavit by 7th of July if you want to file an affidavit,
Ah.
because he has to prepare 11th, we'll hear the
All
matter
all
on
right,
merit.
my lord, I'll try my lord,
All
file it
right.
on 7th of July.
So my lord,
At
the
the-
interim order may kindly pass, so that let them take any time at any moment. Because I will be very little time to have, because they are repeatedly taking adjournments. Last time also.
All that will consider all these aspects on 11th July, at the request.
Let there be interim stay of the annexer notifying the auction notice. Thereafter, let them take time and let them file.
No, auction will take place in 25th of July.
26th.
27th
27th.
27th of July.
We are taking the matter on 11th July, where you, On 11th, if you find any difficulty, mention us, we'll pass the interim order if required, not today.
How obliged.
At the request of Mr. Dayananda Mahapatra and counsel appearing for the, you are appearing for all these opposite parties?
Means opposite
Appearing for
party.
the opposite parties. Let the matter be listed on 11th July 2023. Today, this accommodation has been made
1 to
on the
3.
health ground of Mr. Mahapatra and counsel for the respondents. On the next day, there shall be no accommodation. The matter will be heard, or the appeal will be held on merit. Stop. The respondents may file the supplementary affidavit, if any, by 7th July, please supplying a copy to the land council for the appellant. Mr. Tripathi, land council has appeared for the appellant. Mr. Tripathi has insisted for interim order of stay of the auction notice. So, Mr. Tripathi, land council will be at liberty to mention for such interim order on the next day.
My lord, they may kindly directed to supply me all the documents, whatever they are going to file, well before 11th.
By 7th July, you have already directed that whatever they will file, you supply a copy on you. Please, learned counsel. Yes.
Item 7.
Item 7, petitioner bring for inaction of opposite part number 2 and 3, not taking any action, even if a new construction of road destroying agricultural land as well as, my lord, public money of the, my lord, in this near proximity of the road, there is a 20 feet road is there. Due to some political leaders and some villagers, this road is constructed. I have prayer before the collector as well as executive engineer RD department to inquire the matter whether the road is necessary or not. Till date, no one
Collector
comes to
should
the.
pass an order after hearing.
Yes, my lord.
Aggrieved citizen.
My lord, it is a road from a mandir to the smashan, the burial.
No, his grievance is to be very precise.
His grievance is against
that he's a
against
private
public interest, my lord. I will show you, my lord, that page 14. 14 is that to Tahsildar they are saying that don't make that road. We have got enough road.
Yes.
And without other
Don't
villagers
make the
are also
Wanting the
they
road.
have made them. They have not made them parties. Those who have
No,
will be
we
benefit-
are cutting short the matter.
Yes, sir.
Collector should inquire into his grievance and pass an appropriate order after hearing him.
Yes, yes.
He's an aggrieved
Hearing
citizen.
him and others.
All others.
All
interested
others.
persons.
Yes, yes.
Yes. All right, sir. All right.
And if you find thereafter you have a cause to carry forward, you can come,
Yes.
but
Yes.
not at this stage.
As per the instruction of the villagers, they went to the executive engineer. Executive engineer stated that there is no sanction road, there is a new sanction road is there. Hello, they are.
Hela, kona hela, new na no?
No, sir, no.
Kona?
Sanction.
Directly the collector to inquire.
No, sanction order, no na new? What are you saying?
No, there is no sanction order.
Okay.
All right. You are Mr. Mahapatra.
Sapan Kumar Pal, my lord.
I heard Mr. S.K. Paul and counsel appearing for the petitioner. This is in public interest litigation, challenging the decision of the government for construction of a new road. From which place to which place, Mr. Mr. Patnaik?
It is from a
Baghdad to
And
Kosa.
when you are
From-
filing an
from a
application before the High
mandir.
Court, when you are filing an application before the High Court, the court language is English.
Yes.
You are filing a vernacular representation.
yes,
Yes. Yes, my lord.
it is from a
This is
mandir
not done. Council, you have to make
to-
it translated
to
and
this
file it
smashan.
again.
to the from the village temple. This road is to the
Main
cremation ground, my lord.
Main road to the cremation ground.
And it is on yes on the government plot also.
Construction of the road
What is the
connecting
wrong
the
road?
cremation ground. According to the petitioners, such road is absolutely unnecessary, as there is one road in good condition is connecting all the important places of the village.
Yeah, also alleged in these things that other villages
Another
are
grievance
for
that has
the,
been expressed in these
there.
applications that for construction of the road, the earth from the agricultural lands are being excavated. Orchard for construction of the said road. Ventilating the grievances, the villages whom the petitioners represent. While the representation to the district collector Balasar, urging to stop the construction of the said road in the Dahurda, no?
Dahunda GP
Dahurda GP
in the village of Baghdad.
in village Baghdad, and also for saving the public money. So, according to Mr. Pal, no action has been taken on the said representation. So, we have also heard Mr. J.P. Patnaik, government advocate, who has seriously contradicted the statements made in the public interest litigation, contending that it is on the demand of the villages, administration has taken the initiative to construct the said road connecting the cremation ground. Stop. With it as it may, we direct the collector Balashore to make an inquiry into the grievances as expressed in the representation. It is date is representation, date is 8/8/45/2023. Stop. The petitioner is directed to furnish a copy of the said representation with its English translation to the
Yes.
collector within 7 days from today.
Yes.
Stop. While taking decision, if the collector feels to the other villages, he may issue the public notice for such hearing. Stop. After that, the collector shall pass a reasoned order disposing of the said representation, preferably within a period of 6 weeks from the date of the receipt of the copy of the representation is directed by us. Stop. A copy of this order is supplied to Mr. Patnaik, government advocate, for onward transmission. Urgent certified copy. In terms of the above, before that, this writ petition stands disposed of.
Till date, no coercive action not construction.
Sorry, we have passed an order. It is impliedly so that before that nothing would happen.
What coercive action?
Till date, after final
Lord, the
final
road work
judgment
must
of the
have been
collector.
over because
No,
it
we
is
will not
rainy days
pass.
now.
Because
My lord, till
we
date of the
understand
final
from
judgment of the
April,
collector.
now we are in the month of July. From the April to nothing has happened. We have given 7 days time you file with the order of the order, copy of the order, then they will take the action.
Oblige.
And we have also asked Mr. Patnaik to furnish a copy to the collector.
Yes, I will send.
Item 8.
The constitutional validity of the rule 4 of a group C, B and D of
What is
repeal and
the C and
special
D?
provision is under challenge, my lord. And similar matter has been posted to 24/7, my lord.
24 July.
Yes, my lord.
Heard Mr. N.C. Raut
But here I have filed a miscase for a stay of SOP. They have published on 22/6, my lord. And in one matter, yes, my lord. In one matter, your lordship has passed an interim order.
Interim order.
Any appointment in persons to,
Lord Council appearing for the
And see route.
petitioners. And see.
my lord, that is why
So,
now they are going to
that
regularize.
similar order will pass.
No, my lord, that is appointment. There is no appointment. They are going to regularize. Antedating the appointment.
Stop. By means of this writ petition, the petitioners have, regularization is not appointment according to you.
Yes, my lord. That is
Huh?
also, but
That makes a
SOP
submission, at least in the High Court.
specifically mentioned.
SAP will be stayed.
Later they don't misinterpret.
By means of this writ petition, the petitioner have challenged the constitution to Rule 4 of the Orissa Group B and Group C. Group C and Group D post issue notice returnable on 24/7/2022. Since Mr. M.K. Kuntial, an additional government advocate, appears in web's notice for the opposite parties, no formal notice is called for. Can you file the short affidavit by 24th?
Yes, we are trying to file
Because these similar matters are there.
yes, my
Adoption.
batch
They are
of
only
matters are
copy and paste only, nothing else.
batch of matters are there. I'm trying to file affidavit by 24th.
Yes, file it in that, in this we can adopt it.
Yes,
The
yes.
opposite parties are directed to file their counter affidavit, if any, by the next date.
Date is 24/7.
Do you need any extra copy?
One copy.
Mr.
Let him have
Rao,
one.
Council is request to supply one extra copy of the writ petitions to Mr. Kuntia in the course of the day. Stop in miscellaneous application. Part suggested Mr. Raut, and counsel for the applicant also Mr. M.K. Kuntia, one additional government advocate. This is an application seeking stay of the operation of the notification dated 13/4/2023 and the standard operating procedure dated 22/6/2023, respectively annexure 21 and 22 to the writ petition. Stop. Having due regard to the attending facts and circumstances, we direct the opposite parties. We observe that whatever decision is taken in terms of annexure 21 and 22 by the opposite party, those will be subject to the final outcome of the litigation. In terms of the above, this interlocutory application stands disposed of.
Address.
Registry has,
WPC 3476.
identified some defects. Mr. Minister, Learned Council has undertaken before us that within 3 days, all such defects shall be removed. Item 10.
12.
This is the lot matter.
Yes.
How much time will it take?
At least I hope there's a, it will take some time. I can't say exactly, but it will take some
So
time.
you are the only councillor there.
I am arguing one matter. My learned are also there.
You are there also.
So your lordship is the lead case. Your lordship already argued and parted 34769 of 2020.
Your matters.
My matter. My learned matter, yes. If
What is the
some
name of the
problem today, your
parties?
lordship keep it
Name
to
of the parties?
Dinabandhu Das,
Dinabandhu Das.
WPC 34769.
Page number 3. 2000.
Last time date check is replaced.
Page 3 from bottom 5th. 1, 2, 3, 4.
Mr. Pangari, we propose that we just short orders are there. We not. Sorry. Mr. Rautri, that we like to just complete the short order part.
Yes.
And then we take up your matter.
Okay.
So that we can devote the entire
Right,
part of the day.
Right, just keep the, because
We don't like to keep the.
my lordship is suggesting if your lordship, why not your lordship keep it to next week at 2 p.m. sometime so that it can be completed.
Let us try today sometime.
That.
Do you have any problem?
No, my lords. I was also suggesting the same thing that if it is convenient to my lords, we can keep it at 2 p.m. They'll finish it in one shot.
I think it will be.
2 p.m. today.
Any day, my lords.
Any day
Convenient to my
Dr.
lords, but at 2 p.m.
I am ready, but
Better you come at 2. Let us see. Come at 2.
Today.
Lordship, only
Just take it.
ଆଉ ଗୋଟେ ପାଠ ଅଛି ତାହେଲେ
Some other day that is closed it.
Lordship only they have got leading matters. I have got matters slightly different.
I'll let you point out today because it may not be possible.
I can only finish within half an hour. Lordship.
Thursday, how many matters are there? This Thursday. We are fixing on 6th of July at 2.
6th of July at 2.
And in how many matters are you appearing?
Lordship,
In how many matters are you appearing?
11, 12 matters.
So you please make a short note of your submission.
Lordship, this statutory interpretation.
No,
only
that part we take care. It is a common, but where your difference is there, you are saying that your case is a little different.
Only one line difference.
So only one line difference you point out by a slip of paper so that we do not forget at the time of dictation. As agreed by the council with the parties. Let the matter be listed on 6th of July 2023 at 2 p.m. No other matters to be fixed on 6th of July. Okay. Just the name of the council and all the matters for the opposite parties, Mr. Naik, and see from the causes the council. You are appearing, just give us a list in which matter who is appearing. You also give the list. Here is only one matter, Mr. Rautri.
There are several matters. They are appearing several matters. My lordship is also appearing several matters. One case will cover all the cases.
Common issue is there.
Common issues.
That is what we talk together and but the name of the council must be there.
Some similar matter involving the same issue. It has not come today. Let it come on 6th.
6th, 2. All right.
Item 13.
There is no delay, but the delay petition was filed for condemnation of delay petition that IA number 2250/2021. That is in during the pendant of COVID period.
Heard Mr. M.K. Kunti, London Regional Government Advocate is an IA 2250/2021. Mr. Kunti, having referred to the stamp report, submitted that the delay that has occurred during the pandemic, and as such, the stamp reporting has been done showing there is no delay in filing this petition. This petition, being inessential in nature, is therefore disposed of. Stop. Would you just move admission matter to test today? You have challenged which order?
You can find it from page 41 annexure 2 mail.
All right. How you are aggrieved by that order?
Yes, my lord. How am I, that your lordship turn to page 39, that was the subject matter of challenge in the writ petition, my.
Huh.
That ground of rejection, your lordship can find it. That two last three paragraphs. Page 39, my lord.
Page,
39, my lord. Last,
just I'm looking at this paragraph that is in the page 42.
no, my lord, I'm the which was the subject matter of challenge before the honorable single judge, that is page 39.
As per the Commandant General Home Guards.
Yes, ma'am. Your lordship may say on two grounds his appeal was rejected. Commandant Home Guards Gajapati has not recommended for reimbursement of the as Home Guard in Gajapati district. Second ground, my lord, government invited Home Department letter number so and so dated 22/2020 have directed to stop recruitment and abolish the existing.
You are reading from the order passed by the Commandant General Home Guards Orissa.
Yes, ma'am.
Huh.
This was the subject matter of challenge in that writ petition. Once we have stopped the recruitment process and we have stopped the recruitment of Home Guards,
Since?
then we cannot again re-engage.
No, when has the recruitment been stopped?
Yes, lordship, that is 22/2/2020.
Okay.
That was the ground. Once that has been stopped, we cannot re-engage him. But this is a policy decision. And this has been quashed and again has been directed to reconsider.
He has been discharged since 2013.
Yes, ma'am. He has been discharged since 2013, and those who have been re-engaged after 2013 on the basis of recommendation of their commandant. In the case at hand, his commandant has not recommended. And second ground, after 2020, we have stopped recruitment of Home Guards.
Come to the finding of the single judge.
But that part has not been dealt with. That 2020 notification has not been dealt with.
Have you just reflected in your counter affidavit?
At that counter, that was not. We have taken that ground, my lord, and that was the rejection or the in the rejection or itself. That was the ground.
Notification in your
That I have annexed, ma'am.
in your counter.
Page 51.
Yes, annexure 5.
Lordship, page 50, the notification dated 22/2/2022.
Where is the copy?
Page 50.
50.
50, ma'am.
Oh, that is there first and thereafter the forwarding letter.
Yes, ma'am.
And now then come to that paragraph I was pointing to you. How do you react to this paragraph? If the government has decided to reconsider the representation of the petitioner.
Once we have stopped recruitment of Home Guards.
But then just see.
Yes, ma'am. At that time.
He has quoted, has taken the following decision on 28/7/2014, where it has been stated as follows. Come to this page.
Yes, ma'am. I have seen that. Yep, that your lordship can find it that has been what was the government decision, and your lordship can find it from that earlier order that has been annexed to the writ petition.
No, the simple question, I want a simple answer, whether 28/7/2014 such decision was taken by the government.
Yes, ma'am. What was the decision in that? Your lordship can page 33. What was that decision? Your lordship may see that page 33 that has
no, single justice, they reproduced the decision. A part of the decision has been reproduced. Anyway, let us see what is in page 33.
My lord, that the decision of the 28/7/2014. What was the decision?
Is the
that quoted that
there is not a single justice decision. I
yes,
think.
that I am reading. Further, it may be stated that 63 that notification 28/7/2014 Home guards of various duties due to their participation in the illegal strike at Windsor on 22/3/2013 and involvement in capital PS case number 113 dated 23/3/2000. Out of them, 11 home guards have been ordered for reappointment on recommendation of the concerned SP commandants. The SP commandants have also been advised by the Director of Home Guards to reconsider the representation to recommend their case for considering reappointment. Then, my lord, after receipt of the required recommendation from the Commandant Home Guards, necessary action shall be taken. In his case, his commandant has not recommended.
Right.
That I have annexed. Your lordship may see page 45. Your lordship may see page 46 is the last.
All right, just let us find out the page.
Sorry, my lord. Page 45.
Yes.
Your lordship, page 46, columns 17, my lord.
Yes.
Not recommended for enrollment as a home guard of Gajapati district.
All right, heard Mr. M.K. Khuntiya, an additional government advocate, is appealing to the appellant. So by means of this intercourt appeal, the order dated 7/7/2021. This is the order date 7/7/2021.
My lord.
Delivered WPC number 17690 of 2021 has been challenged fundamentally on the ground that the learned single judge, while passing the said order, did not consider very relevant fact. The petitioner was not recommended for enrollment as a home guard of Gajapati district. Admit. Call for the records of WPC number 17690 of 2021. Issue notice. The appellant shall take steps for service of notice on the respondents. One respondent.
Yes, ma'am.
The respondent. Registered post with AD. Notice is made returnable on 24th of August 2023. All right.
A stay of that input order.
Is there, it is for consideration?
But he has filed a contempt there. That
All right. Stop. Meanwhile, the operation of the impute orders shall remain. You have filed an application. Have you filed an application for stay?
Yes, ma'am. That
2280.
Well,
just go to down
No,
to
2280 says condemnation of delay.
Oh, this condemnation
Let
of
us
delay
see.
is
I have
earlier
checked
not
the
disposed of
table.
2280. So 2250. No, this is 50 also condemnation.
no, my lord,
Yes.
that 2280, my lord. That
No,
is
no, we are looking at the cause list which said that is also delay, so we are checking up.
2280, the cost title I am reading, application for condemnation of
my lord,
delay.
that, but 2280 is first stay. Your lordship can find it from my lord's
we'll check.
lecture.
I am seeing the record.
That 2280
Ah,
is for stay, my lord, and 2250 for condemnation of delay. 2250 for condemnation of delay and
find out,
2280.
I think
The scan copy which we have, the prayer in 2280
both the
says
applications are the
condone the
same.
delay.
Oh,
Both the cases, your application is for condoning the delay. Just show the physical copies. Both the application is
But-
there.
Yes.
in 2280, in my copy that
No, but here probably the same copy has been filed, same miscase has been filed twice.
sorry, my lord, perhaps that.
So there is no stay application, file a stay,
2411.
file a stay application.
That
There's the, this
Okay,
other application also,
2280 is same.
in view of the order passed in 2250 of 2021, today, this application also stands disposed of. All right. You file an application.
But in my file that petition,
Well,
there is a
filing
prayer
for-
for
Maybe
stay.
some people filed wrongly.
My lord, that's
And registry
that doesn't-
also separately registered the case on the same content and same prayer.
my
All right.
Item 14,
May it please, my lords. This is a delay of 699 days that I have filed in the petition. But because of COVID, the effective delay will probably be 64 days, my lords, not more than that.
But according to the stamp report, it is 707 days delay.
My lords, the order was of 16/12/2019. COVID started on 20th of March and continued up to May
20th of March
2020.
of 2020.
My lords. So from
So limitation started, the order of this impugned order passed on.
16/12/2019.
So limitation started from that day.
From there, but that
So
period.
even in filing application, you can say that period on that ground can be considered as a sufficient cause. That will not be automatically struck off. This is not the case.
Because before
Because
the.
before that, the limitation started running out.
It started, so that's why I'm
Not
saying
started, was over.
it was over. So the delay by then was 64 days, and from there
That is
to the
not
date of
what
filing.
That is how the limitation is calculated.
My lords may consider because it was within the.
No, we are issuing, have you received, you are appearing for the respondent, opposite parties? Have you received a copy of the application?
Copy after.
You will not file any objection?
No, my lord, that's everything is there. What is in there, the writ appeal counter and order and our written note of submission, everything they have filed. They have filed only our petition and counter of the state and writ appeal.
No, there is a small clarification that I'll make if my lords permit. In the writ petition, no counter was filed because it was disposed of on the first day of admission. There is an original application that was pending on the same issue in which the state filed a detailed counter. So my grievance, in fact, is that if the learned single
Then you
judge.
consider, but whether you file any objection against the application for condonation of delay,
My lord, I will file objection.
say that
My lord, I
you are issuing notice.
I think notice has appeared.
Notice has been issued already, I think.
Have you appeared suo moto or after issue of notice?
No, I have filed a contempt. In contempt petition, they have stated
They have
from
disposed
after
that no
the
notice has been
personal
issued.
appearance, they have filed this contempt, this writ appeal, my lord, to save them from the contempt. And that's why there's so much of delay. And
No, that's not the reason for delay.
that's my
Absolutely
knowledge, my
There
lord.
is
That
no
is
notice of on the,
There's no notice has not been issued.
already, but writ appeal was taken up for, even the copy has been supplied,
My lord.
taken up for
As per
this.
direction of the honorable
Ah,
court,
right,
the copy was supplied.
Have you filed the certified copy in the meanwhile? No. If there is a petition for dispensing the filing of the certified copy,
No, my lord, not been filed yet.
just in I number 2458 of 2021, there's an application for condoning the delay of 707 days in filing the intercourt appeal from the order dated 16/12/2019 passed by the single judge in WPC number 25586 of 2019. Issue notice is 2I, huh? Just, no. Your good name, please.
My lord, Saraswati Mahapat, S Mahapat.
Since MS S. Saraswati Mahapatra learned counsel appears for the sole opposite party, no formal notice is called for. Ms. Mahapatra has informed this court that she has received the copy of the miscellaneous application and the memorandum of appeal. Stop. Notice is made returnable on 19th July 2023. Meanwhile, the opposite party will be at liberty to file the objection if any. Mr. D. Naik, learned counsel, has appeared for the applicant. All right.
My lord.
Item 15.
Item
15.
In item 15, I have also filed an I for condonation of delay, but there is no delay, my lord.
just I number 823 of 2023. Mr. This Kuntia, K. Kuntial and Additional Government Advocate. Having referred to the stamped report, has submitted that there is no delay. As such, this application filed for condonation of delay has become inessential. Stop. In view of the above statement and the stamped report, this application stands disposed of as inessential. Is
Another I for dispensing with certified copy, if your lordship will grant me
16, item 16,
15.
15.
15. 15.
Yes.
there is a, I am allowed that is for dispensing with certified copy. If your lordship-
What is the ground for dispensing with the certified
Because
copy?
we have, at that point of time, we have applied that has not, we have not got that certified copy and we have applied. If your lordship will grant 7 days more time, that so that I can file a certified copy.
At the request of Mr. K. Kantial and National Government Advocate, let the matter be listed on 11th of July. Is all right, 11th of July or 19th of July?
19th.
19th of July. Meanwhile, the defects as identified by the registry shall be removed. All right. 16.
Item 16.
Yes, same matter,
Same.
common judgment that.
There is an application for delay also.
16. But that there is also no delay.
Which is the original case? Because if it is a common judgment, you need not file the certified copy in all the cases. Some cases it has to be dispensed
The
with.
second case is the original case, your lordship, and that item 16 is.
6 of 2022.
Otherwise, you'll have to file
So I'll
certified
file
copies in all the
certified,
cases.
file certified copy in the item 16 so that it will cover both the cases. And I have also applied 2 copies.
Similar order passed in also there in this application, earlier condonation here. You have filed the certified copy here?
No, in that case I have
dispensing
not.
with.
I have paid.
Make up his mind. which
Same
one
on 19th we'll decide.
Yes, yes.
Same order passed, yes. Yes.
Item 17.
Item 17, your lordship, on behalf of Ms. Mahapatra, your lordship, kindly taken some other date.
That's it also.
I have no.
Who is appearing for the appellant?
I am happy. It may be urgent because the entire matter is to be heard on merit. So lordship may fix it to any other.
Delay.
No.
Today it's for condonation of delay, I think. Am I mistaken? No, condonation of delay.
No notice has been issued on the condonation petition.
The respondent has already appeared. So
Appeared, but no notice on the condonation petition has been issued.
yes, there is a limitation. IA number 4108.
Not 08, I think 41.
60 days.
07.
4107. So you serve a copy on her.
DK Mohanty Learned Council appearing for the applicant. This is an application of section 5 of the Limitation Act for condoning the delay
60
of
days.
59 days as per the stamp report. In preferring the intercourt appeal from the order dated 22/9/2022 passed in WPC number 19848 of 2022 by the learned single judge. So issue notice as to vice agencies. Notice is made returnable on 19th.
Yes.
Or 3rd of August.
Any date.
3rd of August.
Your lordship.
My lord, they have already appeared, so.
No, all right. Since Miss D. Mahapatra and Council has already appeared for the opposite party, no formal notice is called for. But we would request Mr. Mohanty and Council appearing with the applicant to supply a copy of the.
I have already supplied.
No, you supply a copy
Yes,
of
I will
the
supply. I will.
application for condonation of delay to the learned council who has appeared for the opposite party. So, by the next date, the opposite party, if is inclined to file any objections, shall file such objection. No further accommodation for this purpose will be provided. All right.
Yes, deep obliged.
My lord is 1st August.
3rd of August.
3rd of August.
Obliged.
Item 18.
May I please, my lords?
Yes.
But here, my lord, I have filed IA 2047-2023 for condonation of delay. As my lord, Annexure 5 Honorable Single Bench Judgment, my lord, was passed on 6/12/2022, my lords. I filed the writ of appeal before this Honorable Court on 14/2/2023, my lords.
All right.
Other defects.
The opposite respondents, my lords, are insurance company,
So we have to issue notice.
my lords.
What are the
Opposite
other
party.
defects, Mr. Das?
My lord. Respondent 1 and 2, 3 is not required to notice, my lord. That the ombudsman's.
Some defects are there.
I will remove, my lord.
You will remove within 3 days.
My lord.
Heard Mr. Ashok Das. And council appearing for the applicant. Is 2047, huh? This is an application under section 5 of the Limitation Act for controlling the delay of 18 days as per the stamp report. In filing the intercourt appeal, challenging the judgment dated 6/12/2022, delivered in WPC number 11342 of 2004 by the learned single judge. Issue notice as to why the aforementioned delay shall not be condoned or any other order or orders as deemed fit in the fact and circumstances of the case shall not be passed. Notice is made returnable on 3rd of August, 2023. Steps for service of notice and the opposite party shall be taken within 3 days from today by registered post with AD.
My lord, opposite party, no, respondent 1 and 2, 3 is not required for notice, my lord, ombudsman then. Only respondent number 1 and 2.
So, at the request of, on the prayer of Mr. Das, and counsel with the opposite party, we delete the opposite party number, name of the opposite party number 3 from the area of the party.
That is the ombudsman, sir.
Ombudsman has no role in this matter.
My lord,
Ombudsman is a purpose is something different.
Therefore, my lord, I would
So
not.
we have deleted the 3. So there will be no questions of issuing any notice.
Formally, I made party because he was party in the lower single bench.
We are
my lord.
deleting now. Ombudsman cannot have any role in this matter. Delete the opposite party number 3.
On my lord, predecessor is doing-
Registry has to strike out the name of the opposite party number 3 by virtue of this order.
So for my defects are concerned, my lord, I will remove the defect, my lord, by
In appeal, the appeal take
5 days, my lord.
Mr. Ashok Das, Land Council, appearing for the appellant, has submitted that, has undertaking that he would remove the defects by 7th of
Within a
July.
week, my lord, so that will be better.
By 7th of July,
Today, my lord, 3 minutes.
3-4 days
7 days time, so that my lord, I will.
for removing.
They're very minor defects. You check up, you can easily remove within 2
By
days.
7th of July.
So file ಅದೆಲ್ಲ ತೆಗೆದು defect ಬರೋದು.
Obliged.
Mr. Das.
Item 19.
Again.
Let's say this is a limitation of 500 above limitation. That is
How many
Highly
days
discussed.
delay?
but calculated
5 years, 386 days delay.
Yes, ma'am.
5 years.
That is, I have given the reason, but
You have given reason. All right. But Mr. Chittaranjan Patnaik and counsel agreeing with the applicant. This is in IA 1334 of 2023. This is an application under Section 5 of the Limitation Act for condoning the delay of 5 years. Why not is it 6 years, 386 days?
very unfortunate.
6 years.
What is appointment on contact basis?
Yes, ma'am. That was
Contact.
it. Actually, they are the contract basis, but because
Contact or contract?
contract basis.
You
So,
written
that is-
contact everywhere, that is why I was confused.
21 days. As per the stamp report.
Sorry.
Issue notice the same way. The notice is returnable on 3rd of August. Take steps within 3 days from today by registered post with AD. Just copy the other applications later part of this. Yes.
Item 20.
On behalf of Mr. Sakti Mishra, may I please your lord? I may permitted to remove the defects within 3 days. And so far the miscase for a condonation of a delay, there are 69 days delay as per the SL, my lord.
You are appearing for whom?
For the appellant, my lord.
No, council, which council?
Shaktidhar
On behalf
Mishra.
of Mr. Sakti Mishra, my name is S. Patra.
S. Patra. The request of Mr. S. Patra and council who is appearing on instruction of Mr. Shaktidhar Mishra and council for the appellant. Let the matter be listed on 7th July 2023. Meanwhile, the defects as identified by the registry shall be removed. No further accommodation for the same purpose shall be provided by this court.
21.
21, my lord, the registry points out some limitation. In fact, I'm challenging the interim order, which is continuing and subsisting. Secondly, my lord, the writ petitioner, he is also appearing. If you directs me, I will, so I can serve copy on Mr. Ponda, who is appearing for the writ petition.
I'm for OP5.
Copy for the IA,
On
copy
behalf of
the
Mr. Panda.
writ of-
Yes, I will serve copy on you.
Now, what is your prayer regarding the interim order?
Interim order, I'm challenging, my lord, which is continuing and subsisting. Now
The writ petition.
writ petition and this the
Have you
registry
filed
point.
any application for vacation before the learning single judge?
No, I was not
That's
made
why
a
you want
party.
to submit.
Impletion of party.
You should apply
petition
for
was-
impletion of the party in the writ petition and file a vacation of stay. Because he says that we are not parties to the writ petition.
We have not been made parties in originally.
Have you filed the application for impleasement?
Then
No.
vacation of stay.
So how are you?
No, I didn't file. Some other persons had filed and that was not entertained.
So you have not also filed in coming to the division bench?
My lord. But the whole writ petition is also not maintainable, my lord. That's my
File
that
and go there and file first an impleasement application and raise all the questions.
Yes.
You do not have the locus to come to the division bench in this patient. When is the writ
Yes.
petition still continuing?
Yes, I can do. You also may observe that and dispose it up.
Heard Mr. Digambar Mistral and
I
counsel.
need a copy of writ application.
Nothing, we are dismissing the appeal. You are give the copies for your here where court is observing. So Mr. Mishra has fairly submitted that the present appellant did not file any impleasement petition before the learned in the proceeding being WPC number
21615.
2165 up to 2020, which is
21615.
21615. See the page 24, huh?
21615.
5 of to 2022, which is pending before the learned single judge.
2020.
2020.
20 is 2020. Stop. By means of this petition, By this means of this appeal, the order dated 4/9/2020 has been challenged after 992 days. Stop. In our considered view, this appeal is not maintainable in as much as the appellant is not a party in the said writ petition. Stop. If the order of interim order is referred above is to be challenged by the appellant, he has to approach the single judge for implement, and thereafter he can raise the objection in relation to the continuation of the said interim order dated 4/9/2020. But without following that procedure, he has straightway come to this in appeal, which is, as we have already observed, is not maintainable. Accordingly, this appeal stands dismissed. However, the dismissal of this appeal will not preclude the appellant for approaching the learned single judge in the said proceeding for his impleadment or after passing the, or for his impleadment. Stop. All right.
Item 22.
Mr. D.K. Mohanty for the just official, just find out the opposite party number, and Mrs. Das has appeared for opposite party number 5 on advance notice. Yes.
22, my lord, I seek to withdraw this application with the liberty to file a better application with better particulars, because there have been change of circumstances after
Right.
filing of the 22, my lord.
Always sorry.
After filing of the writ petition, there have been many change of circumstances, subsequent events which has taken place, which I will need to incorporate.
Have you filed an application?
Yes, I have filed a memo to that effect for withdrawal, my lord.
All right. Heard Mr. Anupam Rath, learned counsel, appearing for the writ petition.
It's a mention memo, Mr. Das, not a separate memo.
Yes,
you
withdrawal
filed?
memo also I have filed.
Flag X.
Okay, all right.
Mr. Anupam Rathul, learned counsel, having referred to the memorandum that the writ petition is filed on 3/7/2023, submitted that in view of the subsequent events, the writ petitioners intends to withdraw the writ petition and for filing the writ petition with better particulars for adjudication. Stop. We do not find any impediment allowing the writ petitioner to withdraw this writ petition for purpose of filing a better writ petition after incorporating the subsequent events. So accordingly, the writ petition stands disposed of as withdrawn with liberty reserved to the writ petitioner to file a fresh writ petition after incorporating the better and further details on the same cause of action.
My lord, only if so advised.
No, that is
My lord,
because the word may has been there.
Yes, because what has happened in the meanwhile,
If so
the
advised.
tribunal has stayed the proceeding because of the pendency of the writ application.
All right.
And for the OP number 3, state is.
OP number 3,
Yes.
Mr. D.K. Mohanty, council, additional government advocate appears for the opposite party number 3.
23.
4 days time is given to remove the defect, man.
You are Mr. Mohanty,
Mr. Biswal, man.
the request of Mr. B. Biswal and the council appearing for the writ petitioner, let the matter be listed on 20th July 2023. In the meanwhile, the defects is identified by the registry shall be removed. No further accommodation for the same purpose will be provided by this court.
24.
No, petitioner in person. Anyone is appearing, just check. Anyone is appearing? No, no one is in the waiting. All right. The petitioner who appears in person is not present for making submission on 9/5/2023. The matter was adjourned on the request of the petitioner. But today, there is no representation. However, considering that the petition is appearing in person, let the matter be listed on 20th of July, 2023.
11th of July.
20th of July. Mr. D.K. Mohanty, London Additional Government Advocate, appears for the opposite parties. All right, next.
25,
May I please also.
Let us, the petitioner person. It appears from the records that the petitioner has not removed the defects as yet. By the next date, invariably such defects shall be removed.
May I please also.
Yes.
This matter related to Sisuwan, and just as submit the background of the case, this honorable court constitute a committee, constitute a committee. 4 advocates are there, and Lordship directed to visit the Sisuwan. In the November 2021, the committee visited the Sisuwan and submitted their report. Basing on the report, they filed an affidavit, a reply to the response to our committee report.
Yes.
Thereafter, we found some irregularity. The affidavit filed by the Superintendent Sisuwan. Then Lordship directed to again visit the Sisuwan to the committee, and as per the direction, the committee constituted by our Lordship again visited on 19/7/2022.
Yes.
Then I submitted report, we submitted report before this honorable court, and thereafter.
When the last report was submitted?
19/7/2022, my lord.
That is the last report, or the
Last.
report thereafter also? is
No, there are no report. And thereafter, time and again, Lordship directed to respond to our affidavit, our report. They have not responded to. Order number 39, 40 and 41, they clearly indicates that they have to file the affidavit to the response of the report submitted by the committee, because we visited and filed a report. And last occasion also, the Lordship directed to comply the earlier order. Lordship, kindly see order number 39, my lord.
I'm reading order number 39.
And 40 also, and 41 also.
Mr. Mohanty,
As
you
a
have
last
not
chance.
filed the
My lord, the last affidavit we have filed, Lordship may see 1st May 2023.
no, whether you file any further affidavit or not.
Further affidavit.
Because you took time on
Yes, my lord.
2 occasions.
My lord, they have taken thrice.
And on 5/4/2023, Lordship directed the last chance.
Yes.
Thereafter also, order number 41,
Yes, there.
lots of, that is I am submitting. And 41, order number 41 also, even if last chance given, then also Lordship given opportunity to file an affidavit, even if they are not
That
complied
I've
the order
seen.
of this honorable
Yes.
court, my lord.
Last order is the 8th of May 2023.
Yes, my lord.
8th of May.
And 5/4/2023, last chance is given.
Then
Then also Lordship consider and directed to file an affidavit. Then also they are not filed the affidavit.
No,
Response to
that is
the.
why I'm asking him whether at all they will file the affidavit or not, otherwise it
This is
closed.
all- This is all regarding development of the Sisuwan, and your lordship can see that how the developmental work is going on. They have suggested for, in the report, they have suggested for.
No,
for-
simple question
Yes,
first.
yes.
Whether are
just
you going
coming
to file any
that-
further
Yes,
affidavit?
we will file, but we have not filed. I'm just placing before lordship that all these works, all these points raised by the committee are mostly compliant. So I will file an affidavit. I have not filed what I checked up. I have given letter. They are coming with certain data.
It is unfortunate that despite the orders dated 5/4/2023, where it has been clearly reflected that the last chance has been given to the state opposite party to file the counter affidavit in compliance with the order dated 19/7/2022 and the order dated 8/5/2021.
23.
23, sorry. No counter affidavit has been filed by the opposite
My
parties.
lord, not counter response to the affidavit.
Response to affidavit dated,
Response to their affidavit.
And in terms, that has been reflected in the order, that reference
Yes,
of this
in
order.
compliance with terms of that order.
That is what. Stop. Even today, Mr. Mahantil, an additional government advocate, prays for some further accommodation. Stop. We are not inclined to grant
My lord, 1 week time because it is just.
extension
adjacent
of
to the High
time
Court.
in this matter.
1 week time may be granted that I can.
Stop. We'll ask the secretary to the government of Orissa, which is the department.
Health
Health
and Family.
department. Health department. Health department. Health
May I request one thing, your lordship?
No, we
Your
are
lordship
asking,
may keep
you,
it to
let him
after
come,
launch.
visit the High
Let-
Court, it's not a very bad place.
Principal
Who is
Secretary- my
the
lord,
secretary of the
principal-
department?
Principal
Child-
Health and
Secretary,
Family
Health, my
Welfare.
lord.
But his superintendent is supposed to file the affidavit.
We do not know, we are asking the departmental secretary to appear before us.
Superintendent is the Sardar Vallabhbhai Patel.
No, we do not know any superintendent as the state.
My lord.
We'll only ask the secretary of the department.
My lord, Principal Secretary, Health, my lord.
Health.
Health and family and health
There
and
is,
family
it must be
welfare.
social welfare department.
Health and Family
Health
Welfare.
health and family welfare department.
This, this.
This one is under Health and Family.
Family
Are
welfare.
you sure?
Yes, madam.
We direct the secretary to the government of Orissa, Health and Family Welfare
Family
Department, to appear before us in person on the next date.
My lord, on virtual mode or?
This is up to him. He will choose, we will not choose. Stop and explain
She may appear on.
about the compliance of the orders dated 22 to about the compliance of the
19/7/2022.
19/7/2022.
19/7.
And
19/7 is all right.
My lord,
That
my
will do. 19/7/2022.
I-423 and 8523.
8522.
If he files a personal affidavit in response to the order dated 19/7/2022, in the meanwhile, his personal appearance may not be required. But that affidavit, we repeat, shall be a personal affidavit after taking all the details in the consideration. So a copy of this order be served on Mr. Mahantil, an additional government advocate, for transmitting it to the Secretary, Health and Family Welfare Department for compliance of this order.
Yes.
Mr. A. Mahanti, there is a 3 writ petitions together.
I am appearing for
There is a very common order. You just follow the order of 19/7/2022. And Mr. Budhia, you are there?
Yes, madam, madam.
Yes, and Mr.
Yes, madam.
Mahanti is there.
Yes, madam.
I am appearing for Maithili Sansad.
And who is appearing for this, the
1582, I'm happy.
158232?
8832, I'm happy.
And 1582, I am happy.
Same demand, same demand.
No, 15832 of 2000.
I am happy.
There are four matters.
Yes,
All right.
same.
So Pratham Tare, Mr. A. Mahanti.
3 matters, madam.
First are
Three
A. Mahanti.
matters, 3 matters.
Arati, who is appearing in WBC 9504/2015. You are? What is your name, please? Sorry?
95 is not connected to deletion and checkup.
That is not connected with these cases, 9504.
Come to the cause title and cause list.
I already connected all the cases. 9504.
9504, who is Mr.
Yes,
Arun
that is
Naik?
there.
Yes, I am appearing with
Yeah. You are Mr.
Arati Mallik.
Nirmal Kumar Sen.
Mr. N. Sen.
Yes, ma'am.
NK.
NK Sen, it is written.
N Sen. All right.
And that include that also in the third 3,
One,
you get in the
two, three,
97
four.
order. And
Four
this you include in 9504. The order is not reflected, 197 order is not there.
Cost item is this. Oh,
Not a
no.
cost item, I'm talking
All
about the
right.
orders.
Yes.
So that order you follow and add this also, then we total 4. And in case it is appearing and other,
5-4 order. 5-4 and 8-5 order.
so you are the petitioner in
Yes, Lord.
185, 183.
Same cause box. No, same
You are the
cause.
petitioner?
Council.
No, council would petition.
What is your good name?
NC Mishra. NC Mishra. Vibhasana Mishra.
NC Bishwal.
Mishra.
Mr. NC Mishra is for 15832 of 2015. And all the matters, Mr. DK Mohanty, learned additional government advocate for the opposite parties.
1582, I am in person.
Budhia is in person.
Okay, Budhia is in person.
Actually, our last order.
Mr. Budhia, when you appear in
Madam,
person in a court,
Yes,
don't
yes,
wear this
madam.
band. It is
I'm sorry, madam.
specific to
That-
the
that's
lawyer.
there, madam.
Next time you
I'm-
just,
I'm- I consumer.
okay.
I am appearing for monthly.
20th of July is all right.
1 week more.
You always time more time.
No, because I have to file this affidavit of personal affidavit of the secretary. It will take.
All right, 3rd of August.
3rd of August.
3rd of
Obliged.
August.
My lord, I am appearing for monthly.
Huh?
Monthly, sir. In this case, I am appearing.
You draw one microphone because the glass barrier is there.
This one you're
My
appearing.
lord, I am
First
appearing
one,
for
second.
monthly Sansad in this case, my lord.
First one. Which
First
one?
one.
First
We
one.
have recorded
Yeah,
it.
My lord, oblige me, lord.
We have recorded.
Next.
My lord.
Because the council appeared on 19/7, you had also appeared. We are following this
My lord.
representation.
My lord,
Okay.
oblige me.
3rd of August, madam.
Third of all.
Hmm.
26.
A public interest litigation, my lord. Praying for a direction to the state opposite party for upkeepment and taking care of the playgrounds and public parks. Last time on 21st February, Lordship directed to take a file counter by OP4.
But they have not.
No copy has been sought.
Have been served.
No.
No, the affidavit perhaps Mr. Nayak has filed. Seems.
Yes. But no copy has been sought.
You are appearing for the petitioner,
Yes, ma'am.
whether the petitioner is alive,
Yes, ma'am.
are you sure?
1 month earlier I was, but today.
No. All right. You are Mr. Panda.
I am Mr. Mahapatra,
Okay.
Devaprasad Mahapatra.
Mr. DP Mahapatra. When council has appeared for the writ petitioner. Stop. In the proceeding today, opposite party number 4, Cuttack Municipal Corporation has filed their counter affidavit. Have you now got a copy?
I know why they have not sought.
Mr. Nayak is appearing for CMC. I will ask him to, he has just.
It will be given to you. Just
will give it.
examine the affidavit through Mr. D. Nayak. Council, is not an additional government advocate? Is he appearing as the additional government?
I am
advocate?
for the government, state.
Sorry,
Mr.
he's appearing in his personal capacity
No,
as
he's appearing in his personal capacity.
Exactly.
Sorry, I'm
Is
sorry.
it for
I'm
the
very sorry.
council?
I couldn't get it.
The
It's CMC council.
and, Mr. DK Mohanty, London Council appears for additional government advocate appears for the opposite party number 1 and 2. Who is appearing for this opposite party number 3?
I am appearing for opposite party number 3 on behalf of Mr. Mahapatra, madam. I don't have power in this case.
DK Mohapatra?
Yes, Dayananda Mahapatra.
What is your good name? I forget it.
MR Pradhan. MR Pradhan.
Mr.
Manasanjan
Pradhan,
Pradhan.
London Council appears for the opposite party number 3 on instruction of Mr. D. Mohapatra. Is the right D? Dayananda Mohapatra.
Dayananda Mahapatra. D Mahapatra.
Dayananda, just right, Dayananda Mohapatra. London Standing Council?
No, my lord, for CDA, my lord. OP3, my lord.
Is it
For-
Standing Council?
Yes, my lord, written.
London Standing Council?
Written, no, my lord, not.
My lord, written or
Let
CDA?
counsel for all that, let
Yes, ma'am.
counsel for the Kotak Development Authorities within brackets CDA. Stop. Let the matter be listed again on 4th of August 2023. The petitioner will be at liberty to file any rejoinder in response to the counter affidavit filed by the opposite party number 4.
Obliged.
The counter affidavit is filed in the proceedings taken on record.
27.
May please your lordship. This is a public interest litigation, my lord, filed by the petitioner. Matter relates to non-availability of safe drinking water in some parts of the state. That is also Kotak city is also that is involved, Keunjhar, Kadhandi, and so and so.
What is
This-
the basis of this claim?
My lord,
What is the basis of this claim that the safe drinking water is not available in
Available.
some areas?
first of all.
Whether have you made any survey or are you relying
That
on
has
any
been
report?
reported, it has been reported not only in print media, nor also electronic media, and the copy of those have already been filed, and that is already in record.
Right.
My lord, that
Just
apart,
tell us whether on the basis of a simple media report
Only
or
news
No,
clippings are the basis of the
Huh?
PIL. Only news
Not-
clippings
not
are
that-
the basis of the
not,
PIL.
not that I would like to place before your lordship that there is an CAG report, my lord. Urban
that's-
Odisha using unsafe drinking water. CAG report has been placed before the assembly, my lord. I am going to place the copy of the report.
By an affidavit.
My lord,
By
obliged.
an affidavit.
Already I have filed, my lord. That is also.
By an affidavit, because you will have the chance of elaborating the facts also on the basis
My
of
lord,
that.
I am obliged to your lordship. This copy of the report has already been filed in the way of affidavit and is also placed in the record, my lord.
Oh, on which date you have filed it?
My lord, I am drawing your kind attention. It has
Because
also been
it
discussed.
records has
Number of
become,
voluminous.
it will become very big. Can you tell us the date?
My lord. I would like to draw your lordship kind attention to order number 43 dated 22nd November 2022, my lord.
43.
My lord, order number 43, my lord.
Yes.
Wherein I would like to place, my lord, wherein the CAG report has also been discussed. The CAG has further found 9 labs set up by the public health engineering organization in collaboration to so and so 8 crores, not conducting 4 tests report conducted by
Whether after this, your affidavit was filed
my lord,
regarding the CAG report,
my lord,
whether the state has filed any response?
no.
Mr. Mohanty, what is happening?
No, that is the long.
Because
back.
no, this is a central government project for the safe drinking water.
My lord.
Yes.
What is called it? Jalodhara Yojana, what is that?
Yojana is there, my lord, but that is not reaching to the
Now,
people, my
my
lord.
learned senior knows in Cuttack town, Amrit Yojana is
Not-
each.
No, we are not concerned with alone Kotak.
No.
He says
No,
it is the
all over
throughout
the
the state.
I'm just-
Interstate.
But you have not responded to the affidavit filed by the petitioner relying on the CAG's report,
My lord.
which is also filed in the assembly.
My lord, may kindly see para 2 of that order.
Read para 2.
Para 2 of that particular order which my learned senior has placed.
We are seeing the para 2.
The
CMC
CMC as well as what.
are directed to file separate affidavit specifically dealing with the above aspect before the next date.
Yes,
My lord.
Have you
CMC
filed it? That is my
No,
question.
that I am not appearing for CMC nor for Watco. CMC and that is.
Well, I am
what
appearing for
State, my lord, state is also obliged to file
No,
affidavit.
that direction, I am just placing.
No, it's all right. We also ask the state to file.
My lord.
That you not, but they are dealing with these two agencies, CMC and Watco, they are particularly dealing with this matter.
All right,
All
they're all right.
We'll
But,
ask
but an observation of the CAG against the state administration,
My
you will
lord.
not respond to that.
But the direction, that is what I wanted to submit.
All right. Who is appearing for the Watco?
Watco, Mr. Bhuyan, he is appearing.
Yes, my lords, this Watco is a government undertaking, my lords. And this is also undertaken for the supply of water. And in fact, my lords, they are also urban areas, they are also functioning. And in view of the order of this honorable.
No, the problem is, learned council, is that you are saying so many sweet things. But according to the CAG's report,
My
these
lord.
are not the realities. Realities are something different and harsh.
My lord,
People are not getting the same drinking water.
my lord.
No, my lords, because of this is undertaking phase by phase, we have done, we have also filed our affidavit. And because of two things, they have also.
You have filed the affidavit?
Yes.
After
already we
this
have,
order?
We have also filed our affidavit on.
No, this after the order number
After
43, have you
five
filed any affidavit?
No, no, sir. We have not received any.
Oh, yes, we have solved this copy.
ନାଇଁ ନା 22/11 ପରେ ଫାଇଲ
22/11 ପରେ ଫାଇଲ କରିଛନ୍ତି?
ନାଇଁ
Right, 6/1/23 we have filed an affidavit.
No, there was a specific query from the court
Yes,
that you are asked to respond to the CAG's report.
My lord.
Yes,
They have
ma'am.
stated, they have given such a number of the districts where the situation is dismal, dangerous, because the safe drinking water is not reaching to the citizen.
My lords, this is when this government WATCO has adopted DFT drink from tap, my lords.
You can have the so many policies
Yes, my lords. We
with the
have
so
already-
many nice words. We are very happy that you are taking such policies, but we want the implementation of those policies.
His allegation upon the entire state. And this honorable court are directed because Ajagars of water supply confined to this Kotak city.
No, I don't think so.
Our affidavit by.
No, I don't think so. You kindly read again this earlier order, order number 43.
Yes,
Order
my
number
lord.
40.
Para two. That the CMC as well, WATCO has directed.
Now, the order also says only the 10 out of the
In view
19
of this
divisions were
direction
covered
will-
by testing.
Yes.
My lord.
CAG only tested only the 10 districts out of 19 districts. So we do not know what is happening in the remaining 9 districts. In the 10 districts, what is their observation? This is not very happy observation about the state administration. You have a special department to look after making the provision of the safe drinking water.
My lord.
And you are the corporation which is looking after all these things.
Yes, my lords. We are.
But you have not filed the counter affidavit.
Yes, my lords. We have already filed affidavit on 6 January 23, my lords. And we have supplied a copy and we have served the copy to the government, my lords.
This order was passed on November 2/11/2022. After that, you have filed any affidavit?
Yes, my lord. On, my lords, in my our affidavit, my lords, by that this honorable court by an order dated 22/11/22, directed WATCO to file an affidavit specific.
That you have filed.
I have also filed rejoinder, my lord.
Against their affidavit?
My lord.
Copy to the copy.
He has filed counter. What he says that he has,
We have filed.
after this order, he has filed the.
Filed-
Oh, that is what, that I'm
Counter.
saying.
Since January
My
2020.
lord, thereafter I have filed rejoinder to that counter, my lord.
Let you file a rejoinder to us.
But they have not given any specific reply to the CAG report, my lord, which is specifically given. That they have to give.
And what
And
about the Kotak municipal area, Mr. Naik?
my lord, WATCO has given only
We have not
affidavit to
Municipal
the Kotak.
corporation,
we have not filed an affidavit yet.
so you will not file.
No, I will file. Not filed yet is what I am saying.
CMC has also not filed, Berhampur Municipal Corporation has also not filed. This, may I pray, my lord, let the state file the affidavit.
The state has authorized these agencies to look after all these affairs. So they have got all data and they are most befitting agencies to file the affidavit. If your lordship will say, we will file affidavit, but they are directly dealing with this matter.
That, do you have any survey? Because it is a central government project. And they require the survey report. Have you made any baseline survey first before implementation of this program? This is the question number 1. Did you carry out any baseline survey regarding identifying the location for creating the source of the safe drinking water? This is query number 1 to you. If you have made the baseline survey, whether have you met the target or not? If not, what is the deficit? Are you aware of all these facts? Making we have done so nothing would do, because it's a public interest litigation, we want some more details. Can you take instruction and file a short affidavit on that aspect of the matter? Can you file a short affidavit? Or are you aware at all that whether there was any baseline survey before the implementing this project of the safe drinking water? What I recollect, his name is Jalodhara.
My
But
lord,
Mr. Pari is not assisting us in this matter also.
My lord, actually, we have implemented a party on the direction of the Honorable Court as regard to the Khannagar railway crossing is concerned.
That you have filed a short
Yes, we have filed the affidavit. Now it is developed to one by part that the WATCO is not doing the work and they have in all over Odisha there is a problem. So WATCO is
next date you just place before us the entire project of the safe drinking water taken by the central
Yes,
government.
yes.
All right, you file it. And you also file these, we are just formulating certain questions. You also respond to those questions by the next date. And Mr. Nayak also file your affidavit.
In second.
Because this annexure 33 at page 134, this is a CAG report. This is not this is a crux of the CAG report. It says urban Orissa using unsafe drinking water. CAG report. It must be a media report.
I don't have a copy, my lords, of this report.
No,
There also let the service copy.
Mr. Mohanty, you have to give a copy of the annexure 33. This is the media report regarding the CAG report. This is that part.
my lord.
You just give one copy to Mr. Nayak.
Also
Your
me also.
photocopy.
Photocopy, my lord.
All right.
Also me also.
I'll respond.
All right. You
Yes.
also give.
Both.
But we want that the central government project of the safe drinking water.
Yes.
Then we'll ask the state government whether they have implemented that project properly or not. Because this is a program that the same drinking water sources will be created throughout the country
My lord.
so that people unnecessarily do not suffer for the unsafe drinking water.
Certain
My lord.
scheme is there. The scheme will fulfill all the criteria, my lord.
My lord,
I have to brought the scheme
My-
by which court can
Man,
keep proper. Yes, I will come that to
My-
this scheme. Yes.
my humbly submission before you, Lord, there are number of schemes, but that is not reaching
No,
to
that is
people.
why. Let us
My
first
lord.
look at the scheme
My
and then we can assess whether the schemes are properly implemented
My
or
lord.
not.
My lord.
What is a particular scheme which was given
There are-
to this project and by which it can be implemented?
You bring all the safe drinking water schemes.
My
Yes,
lord,
yes.
safe
All right.
drinking water. After my lord, 75 years of independence, my lord, women are climbing to the top of the hill for a fetch of water, my lord.
That is
also
unfortunate,
fact.
definitely, but we have to address those
My lord,
issues.
my lord, bhai, oblige me.
We are not here for the blame game.
Nahi,
Nothing. We want the citizen must get the safe drinking
my
water.
lord. I am obliged.
I'm praying all the respective council to serve the copy,
Yes,
exchange the
sir,
copy,
sir.
then I.
Definitely, sir.
In the second matter, my lord, 2746.
Just a minute. Let us be first matter. Let us deal with this first matter.
କପି ଦେଇକି ମୋ ସମୟ ସରିଗଲା କପି ଆଉ କଣ ଏଇଟା ପାଇଁ ଆପଣଙ୍କୁ ଦିଏ
ନା ମତେ ଦେଇନାହାନ୍ତି କିଛି।
ଦେଇନା ମୁଁ ତ କିଛି ଦଉନି କଣ କଟକ ପାଇଁ ନା ଓଡ଼ିଶା
କପି ଦିଅନ୍ତୁ ସମସ୍ତେ ସେ କପି ପାଇନି
କଣ ଦେବି କିଛି ଦେବା ନାହିଁ କଣ କୋଉଠି ଦେଇ ଜରା ଚକଲେଟ କାମ କରୁନି ଆଉ ଅଭିଯୋଗ ପାଖରେ ନାହିଁ କିଛି କାଢିକି ବାହାରେ ଦେବି
By the order dated 22nd November 2022, this court, having noted the observation made by the Comptroller and Auditor General within bracket CAG, close the bracket of India, in their report highlighting the scares of the water treatment plants or the shortage of the water treatment plants as well as the water testing laboratories. Stop. It has been also reflected in the said report that out of 19 division, only 10 divisions were considered for testing. Stop. It has been also observed in the said report. The concerned organization of the state government are not conducting the prescribed test for disinfection, etc. As a result, people of the state has been placed in a vulnerable state so far the drinking water is concerned. In that perspective fact, this court had directed Kotak Municipal Corporation, and what cause the full is Water Corporation?
Yes, my lord.
Watco?
I am mapping for.
What is the full form of what for?
The Watco
Water Corporation of Odisha.
and the Water Corporation of Orissa, the bracket Watco, to file separate affidavits separately dealing with these aspects as reflected in the said order. Your full name is Mr. Bhuya?
PK.
Yes, my lord.
PK Bhuya. You are Mr. PK Bhuya.
Prasanna Kumar Bhuya, PK Bhuya.
Mr. Prasanna Kumar Bhuya, learned counsel appearing with the Watco has submitted that they submitted that the Watco has filed the affidavit in compliance with the said order. But Kotak Municipal Corporation, represented by Mr. D. Naik, learned counsel, has not filed the counter affidavit as yet. However, Mr. Naik, learned counsel, has asked this court for providing CMC a short accommodation for filing such affidavit. Stop. CMC, the Kotak Municipal Corporation, shall file their affidavit by 19th July 2023. Stop. We direct Watco for filing another affidavit by furnishing the answers to the furnishing answer to our following queries. One, whether before implementing the safe drinking water programs, any baseline survey was created for finding out the necessity and location of the source of the safe drinking water. Two, whether for implementation there was any action program with specific time frame considering the urgency of providing the safe drinking water, and what is the success so far has been made by the Watco in providing the safe drinking water to the villages as well as semi-urban hubs of the state of Orissa, in particular reference to the hilly regions where the scarcity of the water in dry season is so acute. People so acute that the people do not find any other alternate source of the water, stop. Such affidavit shall be filed by 27th of July, 2023. Not completed. We are benefited by the appearance of Mr. P.K. Pari, that is Deputy Solicitor General of India, who has submitted that the central government has a comprehensive program for providing the safe drinking water to people. And it is a common knowledge, all the central government programs are implemented by the state organization. We would request Mr. Pari, Deputy Solicitor General of India, to place all the programs of the central government so far concerned with the making provisions for the safe drinking water in different regions to cover the entire country. And also to indicate by taking the instruction from the appropriate authorities about the financial layout for implementation of this state.
In state of Orissa.
Yeah, financial, generally you are to focus on the Orissa.
Yes, yes. That's me.
Stuff. If stuff, he may also procure instruction whether any financial grant has been provided to the state of Orissa for implementation of such program. Stuff. By the next date, such instruction and materials be placed before this court.
Yes, ma'am.
All right.
May I pray for the
My
copy
lord.
of this order, my lord?
My lord, I have got small submission to be made, my lord. I have filed, petitioner has filed the rejoinder to the counter affidavit filed by the ODCO, my lord.
No, all right. That
Right.
we, Mr. A. Mohanty, learned counsel, appearing for the petitioner, has submitted that the petitioner has already responded to the counter affidavit filed by the ODCO. Stop. At this stage, we are not going. We will not delve deep because we need the further materials to frame certain specific directions to ameliorate the acute crisis of the safe drinking waters in some region of the state of Orissa. So for that purpose, let the matter be listed on 7th of, let's make it on 14th of August.
14th of August.
2023.
Oblige, my lord.
All right. Mr. D.K. Mohanty, an additional government advocate. Mr. Devashish Naik, and counsel for the CMC, has appeared for some of the respective opposite parties. It's all right.
May I pray for a copy of the order?
I will supply all of you.
My lord.
The copy of this order we supplies to the council for the parties.
My lord.
Remaining matters will be taken up. Your matter is WPC 2670.
2746, my lord. Third matter, my lord. So there actually I am appearing for Barampur Municipal Corporation.
All right, this is a common order. We are making it a
My
common order.
I have to file a detailed affidavit that I will file it before 27.
File it.
My-
You're at liberty.
All the matters are
Right.
interlinked. So all the matter may come up on same day, then it can be.
No, this we are making a part of common order because this is all relating to the water.
My lord.
So this is make a
For the
common
entire-
order, WPC 2670 2020.
May I pray one lord, my lord, this Mr. Bhupta and Mr. Raigur is appearing in different cases. In their name may be reflected.
On the next date. At WPC 2 other matters are being under the same common order. All right, the remaining matters will be taken up after the recess.
My
Yes.
Lordship, in fact, to refresh Lordship's memory, may I drive Lordship's kind of only some relevant pages of the brief Lordship and some facts Lordship too. Because last 2 months, that's it. My learned friend had taken time only to give reply. Lordship, here the rules, Lordship, that is at annexure. Lordship, annexure 10, page 93, is under the validity of the rules. At annexure 10, running page 93, Lordship. Just I will read one paragraph of the rules, Lordship. Lordship, got it, Lordship, page 93.
Yes, yes.
Lordship. Lord, it is 29 July 2021. In exercise of powers conferred by the proviso to Article 309 of the Constitution of India, in supersession of the Odisha level, village level workers recruitment and condition service rules on 8, except as respects the things done in or omitted to be done before such supersession, the governor of Odisha is pleased to make the following rules to regulate the method of recruitment and conditions of service of the persons appointed to the post of Panchayat officers, namely Lordship. Lordship, in the first paragraph of the rules, there's two things, Lordship, emerges from this fair understanding of the rules, Lordship. First, they are saying, Lordship, in exercise of their power under Article 309, they have come up these rules. And in supersession of the old rules, Lordship, that is called Odisha village level workers recruitment and conditions of service rules 8, they have come up this rules, Lordship. So then, Lordship, for Lordship's kind perusal, Lordship, straight I come to 309 of the article, then I'll come to the facts, Lordship.
Easy to 9 only you read the proviso part.
Lordship.
Right.
Well, recruitment and conditions of service of persons serving in union or state, Lordship. Then I'll come to proviso, Lordship. Subject to the provisions of the Constitution, acts of the appropriate legislature may regulate the recruitment and conditions service of persons appointed to public services and posts in connection with affairs of the union or any state, provided that it shall be competent for the president or such person as he may direct in case of services and posts in connection with the affairs of the union and for the governor of a state or such person as he may direct in case of
No, it is
services.
just read that way. You are scanning in different places. It is president for the Union of India
Lordship,
and the governor for the state.
for the state, Lordship.
Yes.
Lordship, that is their Lordship. Then Lordship, and so far the second Lordship, the first paragraph of the rules, they're saying it is supersession of the Odisha level, Odisha village level workers recruitment and conditions of service rules 2008. Lordship, so far this rule is concerned, Lordship, my humble submission, this rule has come up for the first time in 1994. Lordship, kindly have a glance to my brief. Just I have, though I have not annexed the 1994 rules. But by an
These rules
annexed
which have been suppressed, that was of 1994.
1994, Lordship. Then it was amended in 2008. Now they have come up with this
2021
rules, Lordship, in supersession of this 2008 rules that I have annexed to Annex 3. Page 53, Lordship. Move it.
Yes.
Page 53, Lordship. Lordship, it is 11th December 8. In exercise of power conferred by the proviso of the Article 309 of the Constitution of India, the Governor of Odisha is pleased to make the following rules to regulate the method of recruitment and conditions of service of the persons appointed to the post of village level workers, namely. State Lordship, come to 2E.
Yes.
Definition, there is Gram Panchayat Secretary. Means the secretary appointed by the Gram Panchayat as per provisions of the Orissa Gram Panchayat rules 1968. If Lordship can come to rule 13, Lordship, here we can get Lordship, that is 1994 rules, earlier that was page 58, Lordship. The Orissa village level work, let's see, Odisha village level worker and lady village level worker recruitment and conditions of services rules 1994. Regulations of orders corresponding to the rules and led immediately before the comments of the rules and hereby repealed. So earlier my humble submission, this rule was the Odisha village level leadership workers, these rules. Initially, it has come up in the 1994. Then subsequently by of amendment, they have come up 2008. And this Annex 3 leadership, this 2008 amendment, it was meant only to accommodate the Panchayat secretaries by giving promotion to them as VLW leadership. The rules are meant for. So leadership here is very important to note leadership. In fact, this is a post under the state government, and it was the appointed authority that was the collector. But by upgrading, because the cadet secretaries are there, the government took a conscious decision. Now we will accommodate all the secretaries in this post leadership in the BLW post. That's why this rule has come up. So that's my humble submission. The government is quite competent to bring these rules, and actually they have given promotion to the all cadet secretaries to post of BLWs. Then leadership, now the present rule leadership, they are saying, leadership kindly come to, I have given a compilation leadership, so because so that judgments leadership. And one judgment is very clear to clarify the status of the Panchayat secretaries leadership of the Gram Panchayat under the Gram Panchayat Act and Rules leadership. Leadership kindly come to page 67, the compilation I had given that judgments leadership on the very day. There is because in the meantime, they have come up with a subsequent number of amendments, but in the judgment leadership, section 122, what was the prior to the amendment and what are the after amendment, that has been clearly defined in page 67 leadership.
Compilation. Is not here. Physical records have not been. Finding the records. I am getting in the scanned records only the list of citations. Not there is nothing like that compilation.
In fact, Lordship, I was relying upon the compilation. Lordship gone through that compilation for us. That is missing, but Lordship has gone through the compilation last occasion. Lordship. Judgments. List of citations. List of citations.
No, that is there. The list of citations are there. This compilation, okay.
In fact, Lordship, after 7th amendment, as in the statute itself, there is a post of Panchayat secretary. But after 7th amendment, the state government came up with the amendment, and for the first time they inserted a post that is executive officer of the Gram Panchayat.
So Panchayat executive.
Panchayat executive officer Lordship. In fact, in this judgment, the very same amendment was under challenge. The virus of the entire constitutional validity of the amendment was challenged, and this is the Lordship. I am relying at page 67, where the Honorable Court has given the comparison. What are the before amendment?
No, just Mr. Dolui, that important aspects in your case is to show first, if you just plead for the striking down of any legislative provision, including the subordinate legislation, you are to show two aspects. First, that the person who framed that rules or the regulation, he did not have the requisite competence to it.
Lordship.
Number one.
Lordship.
Number two is that is ultra bias.
Lordship.
Right.
Lordship.
These are the two components.
Lordship.
And then you can go to show this is arbitrary.
In fact, Lordship, I am doing same job, Lordship. First,
because restructuring of the cadre also
No,
is the
I'm not.
exclusive domain of the executive.
No, I'm not on that, Lordship. I'm just to satisfy Lordship regarding competency first. Then I'll come to the.
Because you are referring back to the old rules. That is the anxiety that I'm expressing
My
to
humble
you.
submission before Lordship, because entire confusion they have created, Lordship. They are nowhere they are saying that we are creating a post. We have come up these rules to give appointment for an officer which will work under the Gram Panchayat. That is the entire confusion. And Lordship, kindly remember last occasion only I have drawn Lordship kind attention. Only luckily they have admitted in their counter that they are saying no. Yes, we are giving this appointment. We will work under the Gram Panchayat and not the same provision, Lordship. That's why I'm bringing Lordship section 122. Lordship, this is 2008, page 63. Lordship, it is 122. Prior to amendment, it was officers and servants of the Gram Sasam, and after amendment, it was executive officer of the Gram Sasam.
That we have noticed, yes.
Lordship. Then Lordship kindly see. Just I'll read Lordship para 14. How the same, because while bringing such law, Lordship, amendment, they had kept this executive officers under the control of the collector, PDDRDA, and other officers, Lordship. It was challenged before Lordship, and by this virtue of this judgment, a Lordship declared ultra virus business provision 122(3). It is complete ultra virus the constitution, and accordingly they have amended the Gram Panchayat Act. Now they are saying, Lordship, this post is under the Gram Panchayat, and they will work under the control and supervision of the Gram Panchayat, Lordship. The Lordship, kindly I am reading from para 14, Lordship.
Of which judgment?
Lordship, the same judgment, page 71, Lordship. This judgment, Lordship, Fakir Mohan versus State of Orissa. Fakir Mohan, it starts from running phase 49. Fakir Mohan Das and others versus Government of Orissa, Lordship.
Of your compilation.
Lordship, अपने compilation, Lordship. Lordship, sorry.
Serial number 7.
49 page. Serial, no, sorry, Lordship. Sorry, Lordship. Serial number 7.
Some other name you have given, but okay.
Serial number 7, Lordship. Fakir Mohan Das and others, Lordship.
All right.
Lordship, I'm reading from para 14, Lordship, it will be very clear. Page 71 of compilation. Judging from the above angle, we find that in view of the provision under Article 243G, legislature of a state has the authority to make provision of law to endow the panchayats with such power and authority to enable them to function as institution of self-government and to provide such powers which may contain provisions for devolution of power and responsibilities of the panchayats at the appropriate level. Before amendment of the Act in 2004, section 122 provided that subject to general or special order, if any made by the state government, there shall be a secretary and such officers and servants for the Gram Sasam as may be necessary for enabling the Gram Panchayat to exercise its power, discharge its duties, and perform its functions for carrying out the purpose of the Act and rules made thereunder. It also provided that in that section that the Gram Panchayat rules shall provide matters relating to the appointment, qualification, manner of recruitment of the secretary and officers and servants, their salary, allowance, etc., and all other conditions of service, including the exercise of disciplinary control and provision over such officers and servants. The pre-amended section 122 also provided the state government may provide a common cadre of post and service of the Gram Sasams and made it clear that any conflict between the provisions of any other law as aforesaid in the Gram Panchayat Act and rules made thereunder, the matter shall prevail. The latter shall prevail. Then Lordship, the kind of permission set I come to save the time, para 17, Lordship.
Okay.
When the matter stood thus, the criticism by petitioners of section 3 of section 122 still remains to be considered. Answer of the state government on aforesaid point is flimsy. According to the counter affidavit of the opposite party, state the workload in the panchayats had increased and still likely to increase manifold in view of different developmental schemes introduced by both the central government and the state government, and huge flow of money from development and therefore additional staffs are necessary to cope with that pressure of work and to properly monitor and utilize the funds allocated and allotted. This part of the logic of state also run consistent with provision of law and a competence of the state government to create posts to the assign and interest work of new employees of the panchayats. But further logic of the state that VAWs and VLWs remaining in the dual charge of the are to remain under the specific control and the supervision of the director, collectors, and district panchayat officer, as stated above, is unacceptable. Inasmuch as if the executive officers of the panchayats who have been bestowed with all responsibilities relating to maintenance of records, registers, and cash be kept under the control of the bureaucrats relating to their service conditions and function, then the panchayats cannot function with independence, and that is how the that would interfere with the constitutional mandate of self-government. For the regions assigned by the state, if VAWs and VLWs are to function as executive officers, then their duties and responsibilities with respect to the duties in the panchayat and their services should be within the control of the gram panchayats, or else gram panchayats may suffer from any discipline or refusal of negligence to carry out the lawful order of sarpanch or panchayat S2 case may be. Apart from that, there may be class of priority to carry out specific orders issued by two authorities, panchayats and states. Then para 18 lordship. The argument of the petitioners is that in the event of the conflict between the rule and act, rule shall prevail. And because the amended provision of the section 122 is conflict with rule 212 lordship, the amended provision of the act will be of no avail. Such argument has no legal force inasmuch as it is a treaty law that in the event of any conflict between act and rules made thereunder, the former will prevail. At the same time, it is treaty law of that rule framed in the statute should be in conformity with the act and not in deviation, derogation, and contradiction of the provision in the act. Therefore, rule which in existence conferring different rights and duties of the secretaries of the gram panchayats is automatically taken away. Amendment of sections 123. However, when subsection 3 of section 122 confuses the issue and makes the provision of section 122 and 123 inoperative in its amended form and hampers the right of the panchayats in the matter of self-government, the orders under Annex 1 and 3 cannot be accepted as legal, valid, and in conformity to the Article 243G of the Constitution. For the aforesaid reasons, we dispose these writ applications with conclusion that provision section 122(3) of the Act ultraviolates the Constitution, and in view of that amended provision, section 122 and 123 of the Act relating to appointment and function of the executive officers cannot be done validly and legally as concerned thereof. The circulars Annex 1 and 3 also quashed. So, Lordship, now after declaring the same provision as ultraviolates the Constitution, this is the second attempt by the state government. Now, Lordship, they have tried the supersede, Lordship, to encroach over the court's order, Lordship. Now they have come up with the new rules, and by imposing the same terms, by bringing the employees of the gram panchayat to their control, and now they have created these rules to have a control on the gram panchayat, Lordship, to give to appoint a person who will work under the gram panchayat under the direct control of the state government. Then, Lordship, kindly come to page 20. Earlier in the year 1990, also, Lordship, 1998. It has already been tested by the full court of this honorable court, Lordship. Lordship, kindly come to page 20 of my compilation, Lordship. Sri Adit Chandra Jana versus Khandat Gram Panchayat and others, Lordship. Page 20. Here the question, Lordship, whether the Panchayat secretary, the person working under the Gram Panchayat, whether he is holding a civil post or not. That was the Lordship, the only question there. And the Lordship straight I have come to, just I am reading the conclusion part.
Yes.
Not to kill court's valuable time, Lordship. Let's start page 11, Lordship, para page 31. Page 31, last paragraph, Lordship. This is a full bench judgment, Lordship. Lordship, got it? Page 31, just I'm reading conclusion, Lordship. A conference of the provisions makes it clear that under the Act and rules, the power to appoint secretary and to take disciplinary action against him vests with the Gram Panchayat. Power of removal also vests with the Gram Panchayat. The relationship between the Gram Panchayat and secretary is that master and servant. The state cannot be said to be the master of the latter. That being the position, the conclusion is inevitable that secretary of the Gram Panchayat does not hold civil post under the state government and is not a government servant. Since 1998, this is already been decided, and subsequently, in Lordship, contrary to this provision, they come up with the amended 1994, which has been declared ultra by the Constitution, adherence to the Constitution by this honorable court, plus by the subsequent judgment. Then, Lordship, just only one finding, page 18, Lordship, kindly see. It is also judgment of 1987 by division bench of this Honorable Court Lordship. In case of Satish Chandra Das Adhikari and another for state of Orissa. Page 18, just Lordship reading, just only 4 to 5 lines, Lordship. Page 18 of the compilation, Lordship.
Yes. Going backwards.
Okay.
Lordship, just reading the from first paragraph, Lordship. 1, 2, 3, 4, 5, 6, 7, 8, 9, 10. 12 from bottom 12, the Gram Panchayats, Lordship. Lordship, the Gram Panchayats are statutory bodies. They are mini legislatures functioning in remote corners of the lowest levels of the state. They should be allowed to function independently, and so long they do so and commit no illegalities and don't contravene any of the provisions of the Act or rules framed thereunder, interference with their sphere of work by officers of the government, by superimposition of committees and subcommittees which are complete strangers and non-entities in the scheme of the Act, should be undue interference, as the present case will sound death knell of democracy at the lowest level. So this is observation since 1987. Lordship, this attempt was made in 1987 to make subcommittees, committees, and to get control over the Gram Panchayat. It has been declared bad by this Honorable Court, Lordship.
Yes.
Then Lordship, kindly come to Article 243G per moment. Then I will come to the statute, Lordship. I am trying my best to conclude to argument, Lordship, very quickly, Lordship. Article 243G.
Yes.
Lordship, powers, authority, and responsibilities of panchayats, subject to the provisions of the Constitution, the legislature of the state may by law endow the panchayats with such powers and authority as may be necessary to enable them to function as the institution of self-government, and such law may contain provisions for the devolution of powers and responsibilities upon panchayats at the appropriate level, subject to such conditions as may be specified there with respect to preparation of plans, economic development and social justice, the implementation of schemes, economics, developments and social justice as may be entrusted to them, including those in relation to the matters listed in the 11th schedule. So, Lordship, the Constitution itself provides the state government to make law, Lordship. It is enabling provision. And Lordship, kindly come to Lordship, it's a Gram Panchayat Act then, Lordship. Lordship, 122, I want to draw Lordship, kind attention, section 122, Lordship, the executive officer of the Gram Sassan, Lordship.
Hundred?
122, Lordship, 122. The very post, Lordship, that is executive officer of the Gram Sassan.
The powers of inspection and supervision.
Establishment conducts business, Lordship, chapter 12, Lordship, that is 122 of the Odisha Gram Panchayat Act 1964, Lordship.
Yes.
Lordship, executive officer of Gram Sassan. For every Gram Sassan, there shall be a Panchayat executive officer to be appointed by the collector, who shall maintain the records of the proceedings of the meetings of Gram Panchayats, remain custody of all such records and documents, cash and valuable securities belonging to the vested under the direction, management, control of Gram Sassan as may be prescribed, exercise such other powers, discharge such other duties, and perform such other functions as may be prescribed, The Panchayat executive officers appointed under subsection 1 shall act as within the local area of such gram or gramos as may be assigned to them by the collector. Then 3, subject to the provisions of section 1, the Panchayat executive officers shall function under the control and supervision of the Gram Panchayat Lordship. This is the post Lordship. Then your Lordship kindly come to section 150.
Yes.
This is power to make rules, Lordship. Section 150.
Yes.
The state government may, after previous publication, make rules not inconsistent with the provisions of the Act to carry out all or any of the purpose thereof, and prescribe forms of any matter for which they consider that forms should be provided in particular and without prejudice to the generality of the foregoing powers. Such rules may provide for regulating the duties, functions, and powers of Gram Panchayat, generally determining the relationship between Parishad, Samis, and Gram Panchayats, and for the guidance of Gram Panchayats in all matters connected with carrying out of the provisions of this Act. Fees payable in respect of applicables, including applications for appeal, review of revision that may be filed before the different authorities under the provision of the Act. Any matter which has to be or may be prescribed under this Act. All rules made under this section shall be laid before the Legislative Assembly as soon as possible after they are made for a total period of 14 days, which may be comprised in one or more sessions, and shall be subject to the such modifications as the Assembly may take during the said period. And Lordship, can you see the said rule that said statute, 2 rules also there, Lordship. One Odisha Gram Panchayat rules 2014, Lordship. Just followed by the Act, Lordship.
You are referring to which rule?
Lordship, Odisha Gram Panchayat rules 2014.
No, that we have got, but the particular rule you are referring to?
Lordship, rule, Lordship, I'm not, now Lordship, straight I am coming the very first paragraph of the rules, because my humble submission, all these rules, they have come up by in excess power, section 150 of the Gram Panchayat Act. All the rules, Lordship, my humble Lordship, either the election rules, either the Gram Panchayat rules 2014 or Gram Panchayat rules 1968, all the rules they have brought up in exercising their power as prescribed under section 150 of the Gram Panchayat Act. So that's why my humble before Lordship, because Article 243G is enabling provision. The state government has come up with the rules, Lordship, as very some provisions by amending the statute. They have the power to
147.
To Lordship to come up with the rules in exercising their power, section 150 of the Gram Panchayat Act, Lordship. So now in the present case, Lordship, they have exercised the power under Article 309. That's why I'm saying, Lordship, competency. Just so far the competence concerned, they could have been, Lordship, exercise the power section 150 because they are creating a post under the Gram Panchayat under section 122 of the Gram Panchayat Act. That's why they could have been exercised power under section 150 of the Odisha Gram Panchayat Act. But they have not done this, Lordship. What they have done, Lordship, they have in supersession of the earlier rules, Lordship, that is VLW and VLW recruitment rules, Lordship. That is a complete state government post, Lordship. That is a post under the state government. That is state government post, Lordship.
But according to you, this post are not under the state government.
Lordship.
No, this post under not state government.
The Gram Panchayat executive officer, Lordship, my entire humble submission for Lordship, the post is of Gram Panchayat. It is, Lordship, from the arising out of section 122 of the Gram Panchayat Act.
I understand that. My question is something different.
Sorry, Lordship, I could not understand.
Suppose some cadre can be created by the state government.
Lordship.
For purpose of working under the Gram Panchayat.
Lordship.
Right.
Lordship.
There can be the various purposes. Gram
Lordship.
Panchayat does not only under these Panchayat, because in view of the different programs of the state government, under the Panchayat, they execute so many programs. Suppose of the rural water supply,
Lordship.
agricultural development. This is under the Panchayat, they are consultatively, they work together.
Lordship.
But if that is a post for the Panchayat,
Lordship.
then absolutely your argument is very correct.
Lordship. My humble submission is
because the intention of the state government is that they will work under the Gram Panchayat, never say they're the employees of the Panchayat.
Lordship, they have said, Lordship.
Where?
They
That
have-
is why
Lordship,
they
that's-
say they will work under the Gram
Lordship,
Panchayat.
kindly.
Where the control has been given to
Lordship,
the panchayat.
Lordship, let I come to Lordship, paste their 125 of the brief, Lordship. 125 of the brief, Lordship, their counter. They have admitted in their counter. In fact, Lordship, very cleverly, they have done these rules without whispering a single word that this person should work under Gram Panchayat. But luckily, Lordship, page 125, they have admitted on internal 7.
Whether a court should read their counter affidavit for purpose of understanding the rules.
So, Lordship,
rule is an independent entity. We can say that this stand taken in the counter affidavit is grossly wrong. We can also observe these people cannot be treated as employees under the panchayat.
Lordship, deep Lordship, and Lordship, kindly see the very nomenclature of the post that creating a post under section 120 of the Gram Panchayat as panchayat executive officer. And Lordship, kindly see the purpose, what they will do. They will work under the Gram Panchayat and they will exercise their duty.
Come to their counter.
Lordship, kindly 125, Lordship.
Then by this opposite party number 1.
State government, Lordship, they have come up with this counter.
Yes.
Lordship, I will read from 1, 2, 3, 4, 5, 6, 7. It is submitted, Lordship. I'm reading, I'll read from that, Lordship. It is submitted that the impugned PO rules 2021 is not contrary to section 122 of the Gram Act, which provides that every Gram Sashan shall have an executive officer. The contention of the Gram Panchayats were authorized to give.
You are reading from which paragraph?
Lordship, that is internal page 7, para 11, Lordship, para 11, Lordship. I am reading from internal page 7, that only page 125, Lordship.
125. 125 is moreover a full bench of this honorable court.
No, 127 and para, there is no para this.
Lordship, then I'm sorry, Lordship, that is internal para 11, Lordship. Their counter, para 11, I'm reading.
Full bench.
Para 11.
The counter affidavit.
Counter affidavit to state government, Lordship.
Yes, moreover a full bench.
Sorry, Lordship, this is counter dated. I'm reading, Lordship.
They have filed 2 counters.
23/9/2022, Lordship. In fact, they have filed 1 counter. They have adopted in both the cases, Lordship. Because they have filed the counter in case, Lordship, that is 22464 of 21. They have adopted this counter in both the cases, Lordship.
No, but we are looking into the records of 22812.
I'm submitting, Lordship, that case, Lordship. But they
in
have
that
filed.
Counter affidavit, there is no such assertion.
Then sorry, Lordship, the second case, Lordship, they have
Let us
filed
see
this.
the second case, whether it is there or not.
Yes, Lordship, that is connected, Lordship. My friend is appearing, senior friend is appearing in that case, Lordship. Because they have filed an affidavit, they will adopt the counter in both the cases, Lordship.
According to you, these are the identical counter affidavit?
Identical counter, Lordship. Because
So how that can be separate? Just let us see what is there.
they filed 1 counter, Lordship, but in 1 case.
One counter has been filed in the case in WPC number 22464/2020.
These 2 separate counter affidavits.
Lordship.
Come to the paragraph 11 of that counter.
Para 11, Lordship.
It is in response to paragraph 15.
15, Lordship. Lordship. Grateful, Lordship. Just I'm reading the entire paragraph, Lordship, para 11. That the averments made in para 15 of the writ petition are incorrect, disputed, and denied hereby. It is submitted that government has brought a new PO recruitment rules known as Odisha Panchayat Executive Officer Service Method Recruitment and Condition of Service 2021 by notification dated 29/7/21 by superseding the provisions previous rules, and it has come into force by its date of publication, Odisha Gazette bearing SRO number 254. There is no scope for GRS to get promotion to the post of PU. Further, existing GRS will get age relaxation up to 45 years, which is not available to other candidates, and 1% extra max for each completion year of continuous service subject to a maximum of 15%, which is not granted to other candidates. The allegation that the impugned PO rules 2021 is contrary to 122 the Gram Panchayat Act, because Gram Panchayats were authorized to give appointment to the secretary, which is now known as VLW or PO, is not correct. Contrary to the section 122 of the Gram Panchayat Act itself, disputed and denied hereby. it is submitted that impure PO rules 2021 is not contrary to section 122 of the Gram Panchayat Act, which provides that every Gram Sasana shall have an executive officer. The contention that the Gram Panchayats were authorized to give appointment to secretary held PO is totally misconceived and contrary to section 122 of the Gram Panchayat Act 1964. It is most humbly submitted that section 122 of the GA Act, Gram Panchayat Act, provides that every Gram Sasana shall have an executive officer. The impugned PO rules nowhere provide that there shall be no executive officer VLW PO in the Gram Sasana as provided under section 100 of the Gram Act, and Panchayat executive officer will be appointed as per the procedure prescribed in the impugned PO rules 2021. Clearly they have admitted these rules are made to give effect to the section 122 of the Act. So my humble suggestion before Lordship, because had it been so, the state has absolute power to come up with the rules, but not with section Article 309 provides the Lordship. They should come up with the Lordship 150 of the rules. It lacks competency. And Lordship, it is how I'm saying Lordship, it is ultra vires Constitution Article 243G. Milord, they are trying to interfere with the affairs of the Gram Panchayat, which has been earlier that has been declared ultra vires. And in many cases, the law has been already been settled. You can't interfere. Officers can interfere with the self-governance system. It amounts to not interfere with the provisions of the Constitution as enumerated under Article 243G. So my humble son before Lordship, here the applicants Lordship, the petitioners are the Gram Rozgar Sevaks Lordship. They have a different plea so far their merits is concerned. So far the constitutional validity of the statute is concerned Lordship. They have two submission Lordship. First they are saying it lacks competency. And second Lordship, it is Lordship affects the constitutional mandates. It is ultra vires the Constitution, which has already been tested by this Honorable Court. It is an attempt, third time attempt of the state government, only to Lordship to supersede, only to show their supremacy over the judgments, verdicts of this Honorable Court Lordship. Twice a Lordship has already given landmark judgment by full bench and Lordship by division bench. Now they have come up with third attempt Lordship. The same mistake they are saying, doing Lordship.
Whether that can be taken, this point can be taken against a validation act.
Lordship.
Because validation gives the state a very unique power. Even you know that even the constitutional, by way of constitutional amendment,
Lordship,
these three decisions of the Supreme Court, so far the reservation is used, has been debased.
Lordship.
Because it's a power with the state
Lordship.
to validate their action by
Lordship.
way of the legislative channel.
Lordship. Lordship, grateful Lordship. I will answer Lordship. Lordship, kindly see, they have not come up with the rules.
Show that these are the purpose of this act, Panchayat Act,
Lordship.
and the appointment of the employees of the officers under the Panchayat Act
Lordship.
by the rules, under Panchayat rules, is a completely a different domain. It cannot be dominated by Proviso 309, Article 309.
Lordship. Lordship.
And there is a conflict of legislation, and in view of the Article 243G,
Lordship.
This initiative of the state government should be declared ultra vires to the very basic arrangement of the Constitution.
Lordship.
That is your, I think this is your fundamental contention.
Lordship. But Lordship, what my impression, Lordship, perhaps they have not gone through what they have done, Lordship. They have not touched the Gram Panchayat Act rules. They have not, their intent, though their intention to give appointment to have a control over the Panchayat officers and to give appointment them. But what they have done, Lordship, kindly see. They have, in supersession of the Lordship, they have come up with an amendment of the earlier rules, VLW and VLW recruitment rules. It is either they have not touched either to Gram Panchayat or Gram Panchayat rules. If they have not come up with the rules,
Village level workers are the government officers.
Government officials, Lordship. Now by
that is why that if we simply forget about this, what have been stated in the paragraph 11 of the counter,
Lordship.
Forget for the time being.
Lordship.
This can be a note of the government
Lordship.
for the understanding the object and reasons behind of bringing such rules.
Lordship.
But if you only simply read the rules, you do not get any clue to understand that the rules are for the Panchayat officer, except the name,
Lordship.
designation.
Grateful, Lordship. That is there.
That is the Panchayat executive officers can be a name of the post under the government.
Lordship.
Then you cannot challenge it.
Lordship.
Right?
Lordship.
Only according to you says that they will work under the Panchayat, they will discharge the duties there. So they should be treated for all practical purposes as the officer under the Panchayat.
Lordship.
And the moment we say there is officers under the Panchayat, The government has no authority or power to exercise the powers under the subordinate legislature like 309 proviso. So these are an apparent contradictions which lead to the ultra vires of the authority of the government.
Lordship.
All right, that is all.
If they will make a submission, Lordship, it is not affecting 122, then also nothing to say, Lordship. That because BLW is
No,
there,
no,
Lordship.
the problem is that the state government, these uses of procedure prescribed, their appointment will be as per the provisions of the contractual rules 2013. Also, you read it.
Lordship.
They have made so many things under these paragraphs.
Lordship, that is their Lordship. That they will answer, Lordship, because my
Suppose I give you one extreme example.
Lordship.
So where the MGMN scheme is Rega scheme is concerned, that is implemented by in the state of Orissa,
Lordship.
by the panchayats.
Lordship.
Right?
Implementing agency Panchayat, Lordship.
Panchayat, right?
Lordship.
And who supervises those schemes?
Collector, Lordship, collector and BDO, the programming officer, all the government officials are looking after the matter, Lordship.
So you can give the example. Just see, they are for the purpose of the MGMNC Rega, collector is the government officer, he only supervises, and they are not the employees, the GRS and other employees.
Lordship.
They are not the employees under the panchayat, that is under a scheme contract.
Lordship, absolutely correct. Lordship.
Right.
Lordship.
But there is a circular of the state that on the other day you were showing to.
Lordship.
They have placed the services of the GRS under the panchayat.
Lordship.
You have mentioned in the earlier.
But let's see what subsequently they have filed an affidavit that is the state central, because they are abided by the central government circular regulation. Central government has given a verdict, Lordship, by regulation. The all Gramras have will work under Gram Panchayat, and their disciplinary authority will be the Gram Panchayat, not the state government.
Okay.
And Lordship, kindly say the very Annexure 1 for a moment, Lordship. Annexure 1, I have annexed one document. Both the documents I have annexed, Lordship. Kindly come to Annexure 1, Lordship, for a moment.
This is circular of the
State government.
State
By
government.
under the MG, this is the notification of the state government.
This case also is there.
Your Lordship, kindly see page 37
This is the notification.
of the state government, Lordship.
23rd September 1989.
No, Lordship, I'm relying page 37, 20. Lordship, perhaps gone through second case, first case.
We are there in the second case. So if you ask us, we'll go back to the first one.
First case, Lordship. Sorry, first case, Lordship. I have annexed the document in first case, Lordship.
Page 36. Yes.
First case, page 37, Lordship.
Right.
What, 2212.
This is 2246.
25.
Yes.
Lordship, only clause 2 I am reading, para 2, Lordship. Because it is pursuant to the central statute, Lordship, MG Act 5. The engagements will be effected by PRA bodies. Government will have no role or linkage to the engagement of this personnel, deployment, and other related matters. Then, Lordship, kindly come to page 51. It is state government's notification. Then page 51, Lordship, the central government's notification. Page 51, Lordship. Page 51, Lordship. 51.
Of the same.
Same, Lordship. Same brief, Lordship. It is central government's notification.
It is this energies guidelines.
Guideline, Lordship.
Yes.
Page 51, Lordship. There, 1, 2, Lordship. Lordship, just only last line. Clause 2, last line. The staff provided to the panchayats under MJNRGS would work under the superintendence and control of the panchayats concerned, including disciplinary powers. In other cases, they relying where abided by the central government notifications, guidelines. So central government says they are the Gram Panchayat employees. If you are saying all the projects under the Gram Panchayat and implementing it in the Gram Panchayat, then Gram Panchayat should act independently.
Where is this?
All right.
Lordship.
Okay, any other point?
Lordship, last occasion I have elaborately Article 40, I have some Lordship to all things there, Lordship, enter the constitutional mandate judgments also, Lordship. If they will say
Yes.
this post is not under the Grampa, then I have nothing to say, Lordship, because your Lordship is absolutely correct. Your Lordship have gone through the entire letters of their notification. They not anywhere they have whispered a single word that they will work under the Gram Panchayat. Very cleverly they have done this, Lordship. But their entire endeavor only to get control over the Gram Panchayat, Lordship.
Okay. State, yes. First clarify your position. Why have you written in paragraph 11? Is the purpose when the rules rules is absolutely silent about this thing. How can you supplement by an affirmation in the affidavit? What is a gap in the rules? Yeah, you cannot animate something not is in the rule.
That is that has been written.
Come to the para 11.
That is not in accordance with the law.
Not enclosed?
That's not an HU address plus maybe called tomorrow.
Huh?
Not an HU address this matter maybe called tomorrow because
Is he not here?
He was here?
No, he was here. He has a matter for the Honorable Jharkhand High Court virtually is appearing.
He will be appearing virtually.
Retiring for some time.
Want to appear in your presence.
You just introduce the facts.
No, yes, I can.
But the only thing, paragraph 11.
Plus, I am taking lordship to section 150. That's what my learned friend has given the understanding. But in my humble submission, that is not clear.
There is no difficulty. Difficulty is the challenged rule.
Yes, sir.
According to them, this Panchayat executive officer, if they are the officers for the Panchayat, you cannot make rules under the proviso to 309 of the Constitution.
Plus, I am coming to that. Plus, I am taking a loss.
No, first of all, you have to clarify
Yes.
from the rules itself.
Yes.
Later on, come on to counter affidavit that these are the officers from the Panchayat. From the rules first show us. By the nomenclature, we cannot understand anything. You show that these are, but according to since you have exercised the proviso to Article 309,
Yes.
we will only presume they're the officer of the government. Because otherwise, if you read the entire Article 309, it is only to regulate the service of the state or the central government.
Yes.
So if you say they're the state government officer,
These are the state government officials.
okay,
State government officials.
and you are sending to Panchayat to regulate them.
Minus. No, not regulate. The way my learned friend has submitted, not like that. Minus. Yes.
I'm sorry, Milord.
No, okay.
I was just
Learned
told
Advocate General, that what is troubling us, your statement in paragraph 11.
Milord, I'll explain that. Your Lordship will know.
And first of all, the impression that creates when the rules are made under the proviso to Article 309.
My Lord,
This can only be made in respect of the state government officer or the central government officer.
I'm grateful. That is all I'm going to tell your Lordships. That's what I'm going to address your Lordships on.
Then because of two decisions of this court,
Yes, yes.
particularly Justice Pasai's judgment,
Correct, correct.
it clearly says this is an attempt, if you want to intrude to the administration of the Panchayat, this will be ultra-vires to the constitutional arrangement.
Milord,
Under
let me-
Article 246.
I'll answer your Lordship.
Okay,
Would your Lordship look at the prayer in the writ petition?
okay.
Kindly see, my Lord, page 27.
You are referring from which writ petition?
Your Lordship may take, my Lords, 22812, that is the writ.
All right.
You are reading from 22812.
Yes.
If your Lordship sees page 27, my Lords.
Yes. Prayer is coming in page 34, I think 34.
How can we have different pages?
Maybe you are taking up another writ petition. What is your writ petition number?
My writ petition, my Lord, is 22812.
All right, we are on the same writ petition.
Prakash Kumar Chatoi.
We are on the same writ petition.
Prayer is at page 34.
Let me, it is therefore humbly prayed. Are we right there, my Lords? Yes.
Right.
Yes, it is humbly prayed
that this honorable court may graciously be pleased to admit the writ petition, issue a rule in ISI calling upon the opposite parties to show cause as to why declare the notification of 29/7/21 under annexure 10 shall not be quashed, declaring the same as illegal, arbitrary, malified, unconstitutional. So also contrary to the existing rules and appropriate orders in the nature of mandamus shall not be issued. This is very important. To the respective collectors to extend the promotional benefits to the GRS in terms of the Odisha village level workers recruitment and condition rules 2008 and also to the the amendment made in 2012 and 2013. So it's my learned friend's case is that we are entitled to the promotional benefits to the GRS in terms of the 2008 rules.
Yes.
So he is not talking about any 309 municipality, etc., etc. And I'll tell
this notification.
I'll show everything to your lordship. Yes. I have made a small compilation so that your lordships need not have to go through pages here and there. What fell from your lordships was that there could be some employees who are employees of the Gram Panchayat, and there could be also some employees who are employees of the state government who are deputed for certain purposes. I'm glad, my lords. That is the distinction your lordships have already made. Now, kindly see, my lords, look at my small compilation. This is a small compilation, so that your lordships are not troubled. Kindly come to, my lords, let us first see what is the impugned notification and rule under challenge. And that your lordships will get, my lords, at page 55. My lords have page 55, my lord?
Yes, yes.
Your lordship may straight away come to, my lords. Procedure for filling up a vacancies.
Yes.
My lords have page 56, my lords.
Yes, yes.
Page 56. Your lordships will see, I'm sorry, my lord, lordship may straight away come to page 55. In these rules, definition, my lords, appointing authority means the collector of the district.
Yes.
Your lordships have it, my lords. Commission means the Odisha Staff Selection Commission. Director means the Director of Panchayat Raj. District means the revenue district of the state. Ex-serviceman means as defined under so and so. And if your lordships kindly turn to G, my lords, Gram Rojgar Sevak means persons who have been engaged as in Gram Panchayats under the MGNR Manriga Employment Guarantee Scheme 2005. Subject to correction by my learned friend, he is a Gram Rojgar Sevak. Then your lordship may see, my lords, L. Service means, my lordship have it.
Yes, yes, got it.
Service means Panchayat executive officers. Service constituted under Rule 3.
Yes.
So the nomenclature is Panchayat executive officer.
Yes.
And if your lordship sees, my lords, service means Panchayat executive officer, service constituted under Rule 3. Now, Rule 3 says the service shall consist of posts of Panchayat executive officers in each district. In each district. Now, method of recruitment is 4. 5 is reservation. 6 is procedure for filling up a vacancy. The appointing authority will submit requisition to the commission for filling up the number of posts as may be decided, taking into consideration various aspects like cadre strength, need for effective cadre management. So therefore, there is a cadre. Now, 7 is the eligibility criteria. a candidate, in order to be eligible for direct recruitment, must be a citizen of India, not less than 21 years of age, not more than 32 years, as on 1st day of January of the year of publication of the advertisement for the recruitment. He must be able to read and speak, write and speak.
We can
Odia, shall
perhaps
give-
keep these provisions of eligibility.
Yes, these are all there.
Yes.
Now, where is the interest taken care of the petitioners is 2 at page 58. Your lordships have it?
Yes.
The Gram Rozgar Sevaks engaged under the Manriga, who are less than 45 years of age and are otherwise eligible under the provisions of these rules, shall be allowed to participate in the written test, subject to production of a certificate from the collector of the concerned district regarding their continuity as Gram Rozgar Sevak. So earlier, your lordship saw, my lords, the age relaxation was earlier 32 years.
Yes.
That was under 7B. 7(1)B said not less than 21 years and not more than 32 years.
Yes.
So for the persons who are Ram Rozgar Sevaks, if you get a certificate from the concerned
That is
collector,
45 years then.
then you get 45 years. Provided that the Ram Rozgar Sevaks who have been adversely reported and have no continuity in service shall not be eligible. This is one. Then, my lord, conduct of recruitment, pattern of examination. My lords have it, my lords, 8.
Yes.
Now kindly see 5. 8, small 5. The Ram Rozgar Sevaks shall be allowed 1% extra marks of the total marks of the examination for each completed year of continuous service, subject to a maximum of 15%, which means 15 years, which shall be added to the marks secured by them for deciding the merit position, but in no case the marks secured together with the extra marks shall exceed the total marks. So therefore, my lords, the post of the Panchayat Executive Officer is a post under the state government.
Is a cadre of the state
It's a
government.
cadre of the state government. I'm deeply
And
obliged, units. And
State government, but the appointing authority is the collector.
is the collector, is also the state government. Now, the Ram Rozgar Sevaks who are before your lordships, they have been given certain weightages for the
To bring into them the regular establishment.
I'm grateful. Now, let us see what was the rule prior to this. And that your lordships will get, minutes, at page 32. That is a rule which is called the Odisha Village Level Workers Recruitment and Conditions of Service Rules. Your lordship may see page 40. My lord said page 40 minutes. This is the 2013 rules.
You are referring to page 34?
I'm sorry, page 40 minutes. I'm so sorry.
40, okay.
My apologies.
Yes.
My lord, this is a 309 rule.
Yes.
What I read to your lordships was also a 309 rule. And my learned friends, they now say that your rule is ultra vires because it affects these rules. So under this rule, under this 309 rule, my lord, what was the provision? In exercise of powers conferred, my lords have it.
Yes, yes.
In exercise of powers
got
conferred by
your
proviso
point.
to 309 of the Constitution of India.
I got your point, London Advocate General. Just I like to interact that you say the same set of reasons.
Yes.
Will negate the petitioner's contentions because they want benefit of the 2008 rules, but that is also a proviso to 309 rule.
And what they got here was this.
Yes.
Your lordship may just see 2.2. The Gram Panchayat secretaries, in case of non-fulfillment of the availability of Gram Panchayat secretaries, let me read the whole thing. Let me read two. In the Odisha level workers recruitment condition rules 2018, the following sub-rules shall be substituted. In case of non-availability of Gram Panchayat secretaries, the post remaining unfulfilled shall be filled up in the following manner.
Yes.
70% of the vacancies shall be filled up by direct recruitment in accordance with Rule 9. 30% of the vacancies shall be filled up by way of selection from among the Gram Rozgar Sevaks. So if you are a Gram Rozgar Sevak, then 30% of the vacancies will be filled up
From them.
from them.
It's a sort of reservation.
Kind of reservation, your Lordship is right. Now, what they are saying is that we had a right under the 2013 rules that 30% of the vacancy shall come to us.
Yes.
Now, what you have amended is that this 30% reservation is gone. Now, if the 30% reservation has gone, then we are affected by your new rule. Therefore, in the prayer, bereft of what has been argued, Lord, in the prayer, this is their main case. I will also meet what they are saying. Lord, for this, there are two submissions. Your Lordship may take two judgments, I will read them. One is 2003, Volume 2, SCC 632. It is 2003, Volume 2, SCC 632, paragraph 10 at page 639. It is called P.U. Joshi.
Have you given a copy to us?
I'll give them. I have copies. I'll read them. And the second one, your Lordship may kindly note, Millets. This is 2023 3 SCC. 23. Yes, 2023 3 SCC 773, paragraph 13, page 787 is the question framed, and the answer is at para 82, page 817. I have got the judgments, I'll read them. Now, what has been argued before your Lordship is this. I'll read them at the end, Merits. What has been argued before your Lordship is this. That look at the Gram Panchayat Act. Well, your Lordship may see section 122, because my learned friend read it. Yes. Kindly come to, in my small compilation, kindly come to page 10. And if your Lordships kindly turns to page 16, your Lordships will see, Millets, there is a definition of executive officer of the Gram Sasan at the foot of the page.
Yes.
My Lords have it, Millets? May I read it slowly? For every Gram Sasan, there shall be a Panchayat executive officer, which is the subject matter of appointment here.
Yes.
To be appointed by the collector. Your Lordship may kindly note this.
Yes.
To be appointed by the collector, who shall maintain records of the proceedings of the meetings of the Gram Panchayats. Lord, you need an arbitrator to do this. Somebody outside the Gram Panchayat. Because then otherwise there will be never any authenticity to what they decide. Remain in custody of all such records and documents, cash and valuable securities belonging to or vested or under the direction, management or control of the Gram Sasan as may be prescribed, exercise such other powers, discharge such other duties, and perform such other functions as may be prescribed.
Yes.
The Panchayat Executive Officer appointed under subsection 1 shall act as such within the local area of the grama or gramas as may be assigned to them by the collector. Subject to the provisions of 1, the Panchayat Executive Officer shall function under the control and supervision of the Gram Panchayat. Now kindly see note 123, just below that. My lords have it, my lords?
Yes.
Now see the difference in 123. It says secretary and other employees of the Gram Sasan.
Yes.
Your lordship saw in 122, it said executive officer of the Gram Sasan. 123 is saying secretary and other employees of the Gram Sasan. So therefore, the contradiction is, one is where the collector appoints and he is not an employee of the Gram Sasan. The other is secretary and other employees of the Gram Sasan. Let me read this. Subject to such general or special order as may be made in this behalf by the state government, a Gram Panchayat may appoint a secretary and such other employees for the Gram Sasan as may be necessary for enabling the Gram Panchayat to perform its function, who shall discharge such duties and perform such functions as may be prescribed. So, my lords, the Gram Panchayat will appoint a secretary and such other employees for the Gram Sasana as may be necessary for enabling the Gram Panchayat to perform its functions, who shall for enabling the functions, who shall discharge the duties and perform such functions as may be prescribed.
Yes.
So for all the functions of the Gram Panchayat, for all the duties of the Gram Panchayat, the secretaries and such other employees will be appointed by the Gram Panchayat. Let us now see 2 minutes. The expenditure on remuneration or allowances of the secretary and other staff appointed, if any, under subsection 1 shall be borne by the Gram Panchayat. So if your lordships now compare 122 and 123, my lords, they are completely dissimilar from each other. Here the collector is appointing, there the Gram Panchayat is appointing. The executive officer is not paid out of the funds of the Gram Sasan. These employees are paid out of the funds of the Gram Sasan. So that is the distinction between 122 and 123. Exactly. If my lords kindly turns over, my lords. Then we come to 150. Lordship may now see, my lords. Section 150, power to make rules.
That we have read already.
Your lordship may read, I leave that.
Yes.
Kindly now come to rule 125 at page 24. The rules start at page 22. My lords may kindly turn to page 24.
Yes.
Appointment of staff. The Gram Panchayat may, with the approval of the district Panchayat officer of the district, appoint secretary and other staff like scavengers, tax collectors, peons, etc., as may be necessary for enabling it to discharge its duties and functions for carrying out the purposes of the Act and the rules made thereunder, subject to the condition that remuneration of the staff appointed under this rule shall be paid by the Gram Panchayat out of its own internal income and no part of such remuneration out of the grant or allotment sanctioned by the government. So this is a rule under 150 for the staff of the Gram Panchayat, including its secretary.
According to, there is distinct categories of employees
I'm grateful
who are
to you,
involved with the functioning of the
I'm
Gram Panchayat. One is appointed by the state government for
My
a
lord.
limited purpose,
Right.
maintaining the financial discipline and
I'm grateful.
everything. And the others are the exclusive staffs and officers of the Gram Panchayat whose salaries and wages are reimbursed
I'm
from
grateful.
the Gram
I'm
Panchayat,
grateful.
the consolidated
So for
funds.
them, the
Yes.
rules have been framed under say 150.
So according to you, the under section 122, the state government has enough power to
Enough
create this kind of a cadre,
Yes.
and there is no.
And the grievance of the petitioner, that earlier there was a certain amount reserved for us, which you are now taking it away. I will deal with that.
The second part of their
That is their
grievance.
Lord, in fact, that is their argument. That is their case. If you look, Lordship may kindly take the writ petition, my lords. The writ petition part was today. In the first paragraph. So what they are saying is, my lord, there is one writ petition, 22464 of 2021.
Yes.
Your lordship need not take it, my lord. I'll just slowly read. The petitioners in the present petition are Gram Rozgar Sevaks, and almost of them were appointed in the year 2006, pursuant to Government of Odisha Panchayat. Your lordship may not take the brief. I'll read slowly. On the basis of so and so, while continuing as such, the Panchayat Raj Department published notification of 26th of March 2013, amending the provision, that is the rule so and so. In the said rule, it was stipulated that while going for direct recruitment and selection from Raj Rozgar Sevaks, all collectors were directed to recruit them from the post of Gram Panchayat Secretary and VLW by way of selection. The post shall be filled up either by direct recruitment. Collectors were also directed to prepare gradation list of Gram Rozgar Sevaks on district wise for appointment as VLW, taking into their date of joining in the post for consideration. He must have rendered 5 years of service in GRS. A selection committee will be constituted for appointment as GRS as well as for giving so and so. 30% out of the gradation and GRS so appointed since 2006 have been promoted to the post of Panchayat Executive Officer. On so and so 19 GRS were appointed. On 2022 40 GRS were appointed on the basis of 30% reservation. Now, by virtue of the notification on 29/7/21, the 2013 rule has been superseded and the provision of filling 30% vacancy to the post of PEO from amongst the GRS has been amended, which is called as so and so. So that is the grievance. Now let us see, my lord, what is the law on this subject. These two judgments I gave to your lordships. If your lordships first see 2003 volume 2 SCC 632. I have given 2 copies each.
Yes.
Lordship may straight away come to 639, paragraph 10. My lords have it?
Yes.
Paragraph 10. We have carefully considered the submissions made on behalf of both the parties, questions relating to the constitution, pattern, nomenclature of posts, cadres, categories, their creation, abolition, prescription of qualification, and other conditions of service, including avenues for promotion and criteria to be fulfilled for such promotion, pertain to the field of policy, is within the exclusive discretion and jurisdiction of the state, subject, of course, to the limitations or restriction envisaged in the Constitution of India, and it is not for the statutory tribunals at any rate to direct the government to have a particular method of recruitment or eligibility criteria or avenues of promotion or impose itself by substituting the views for that of the state. Similarly, it is open within the competence of the state to change the rules relating to a service and or alter and amend and vary, addition, subtraction, the qualifications, eligibility criteria, and other conditions of service, including avenues of promotion from time to time, as the administrative exigencies may need or necessitate. Likewise, the state by appropriate rules is entitled to amalgamate departments or bifurcate departments into two or more, constitute different categories of posts, constitute different category of posts or cadres by undertaking further classification, bifurcation or amalgamation, as well as reconstitute and restructure the pattern and cadres or categories of service as may be required from time to time by abolishing the existing cadres post and creating new cadres and post. Now, this line is important. There is no right in an employee of the state to claim the rules governing conditions of service should forever be the same as the one when he entered service for all purposes except for ensuring and safeguarding rights and benefits already earned, acquired or accrued at a particular point of time. A government servant has no right to challenge the authority of the state to amend, alter or bring into force a new rule relating to an existing service. So therefore, my submission is, my lord, earlier the rule said 30% will come from there. These are not promotional posts. So it said if vacancies are not available, assuming vacancies are available, nothing. If vacancies are available, 70% by direct recruitment, 30% from this place. So this is not even a promotion post. You have no right. Assume vacancies are not there, then they get nothing. So here what we have done is, we have said that this executive officer is a post under the government, appointed by the collector. A 309 rule was earlier there. Now this 309 rule is saying that instead of that 30%, you compete, we give you age relaxation, and we give you weightage in marks. The next judgment is a relatively newer one. State of Himachal Pradesh versus Rajkumar. And if your lordship sees, the question here has been summarized at para 10, page 639. The question is, which rule will apply?
No, it's clear law.
I'm grateful.
Since the state of Tripura versus Ajit Chakraborty first rule in
Yes,
2016.
yes. So therefore, the date when the vacancy arises, that will be the relevant date. So
nobody can claim the recruitments under the old rules.
Right, right.
When the old rule has been repealed.
Right.
By the express permission.
Right. I'm grateful. So therefore, my submission is this. The argument was that the executive officer is an employee of the panchayat, of the Gram Panchayat, and that being so, Millets, his recruitment has to be done under the Gram Panchayat rules. Your lordship saw there's a distinction between 122 and 123. For the employees of the Gram Panchayat who are paid and remunerated by the Gram Panchayat, are the secretary and downwards. For them, there is a set of rules under the Gram Panchayat.
Problem has been a little bit, confusion has been created by your paragraph 11 that Mr. Dolu has read.
Your lordship have already said that the counter is neither here nor there for interpreting a statute.
Exactly.
Ultimately, your lordships have to test, my lords.
We were to test by the words available in the rules and act only.
And my lords, on two grounds, you can say it is ultra vires. Either I didn't have the power at all, want of legislative sanction, competence. The second is, it is so arbitrary under Article 14 that it shocks your lordship's conscience. So it is not been pleaded. My lord, unless your lordships come to hold that 122 is also a post under the Gram Panchayat and the salaries are paid out of the Gram Panchayat, etc. My lord, so that is not there. So once that's there, the competence goes. If there is a cadre, if they're a government servant, then 309 of course applies because they are employees of the state.
Exactly.
Grateful to your lordship.
Agenda.
In fact,
Within
lordship,
5 to 10 minutes maximum.
yeah, within 10 minutes, I'll control lordship. In fact, lordship, when my senior Advocate General appeared, I was thinking it will be very easy to settle the law, Lordship, because our duty to safeguard the law only, Constitution.
No,
But,
just before you just
Lordship,
take up, Advocate General, that the way he just read this para 11 of your counter.
Let me read it. Let me read it once.
No, and also read it with subsection 3 of section 122.
Yes,
which has been struck down by this court.
Yes. My lord, there is one line which starts, it is humbly submitted.
Yes.
It is most humbly submitted. My lords have that line, my lord?
Yes.
It is most humbly submitted that section 122 of the Gram Panchayat Act provides that every Gram Sasan shall have an executive officer. No difficulty. The impugned PO Rules 2021 nowhere provides that there shall be no executive officer, VLW, PO in the Gram Sasan. Full stop. Well, this is little difficult.
Yes.
As provided under 122 of the Gram Panchayat Act, the Panchayat Executive Officer will be appointed as per the procedure prescribed in the PO Rules 2021. Nothing wrong in that. The slip is here. The impugned PO, the impugned PO Rules 2021 nowhere provides that there will be no executive officer. So that is also not wrong. So, because under 120,
if you line after that.
Yes.
The impugned PE Rules 2021 nowhere provides that there shall be no executive officer.
The allegation that the impugned PO Rules is also contrary.
No, just this use from where you started reading.
Yes, my lord.
It is now most probably submitted that section 122 of the
Provides that every Gram Sasan shall have an executive officer. Let me read further. The impugned PO Rules 2021 nowhere provides that there shall be no executive officer in a Gram Sasan. As provided under 122 of the Gram Panchayat Act, the Panchayat Executive Officer will be appointed as per the procedure prescribed in the impugned PO Rules 2021.
There is no difficulty.
No problem. Therefore, the contrary allegation that the impugned PO Rules 2021 is contrary to the Odisha Group C, Group D contractual appointment rules is totally misconceived, untenable in the eye of law. Similarly, the allegation that the impugned PA rules contravene the provisions of the National Rural Employment Guarantee Act, that is also gone. Said Act of 2005 only provides that under the Manrega has to be executed by GRS. By virtue of the impugned PO Rules 2021, the post of GRS have not been abolished. GRS are still working. The allegation that the impugned PO Rules is also contrary to the Contractual Rules of 2013, as well as the amendments made therein, is also basically denied. It is submitted that the persons GRS who will be appointed as PEOs as per the prescribed procedure prescribed in the impugned PA Rules 2021, their appointments will be as PEOs will be as per the provisions of the Contractual Rules 2013. Therefore, the contrary allegation to the impugned Rules 2021 is contrary to the misconceived.
It's all right. This one line only creates a little bit of confusion.
But in fact, Lordship, during my argument, I have repeatedly said perhaps this is.
This rule does not say there should be no any executive officer under the term system. Yes.
Lordship, perhaps I have repeatedly said this is third attempt of the state government only to undermine court's direction, court's verdict, Lordship. Lordship, kindly see.
That is regarding
the
subsection 3 of
Lordship, no, Lordship. That has been, Lordship, at the cost of the repetition. Lordship, kindly see.
Yes.
After, Lordship, 1 minute, Lordship. After 7th amendment, the state government come up with the amendment of the act. They brought up section 122 with nomenclature, that is Panchayat Executive Officer. But Lordship, for the relevant time, because there was no adequate staffs of the Gram Panchayat, at the same amendment, Lordship, kindly see what are the language employed by the state government. Lordship, kindly, for a moment, again, I'm Lordship, my compilation line, because the comparison is there, Lordship. Same judgment, Lordship. Fakir Moon's case, Lordship, page
Yes, yes.
page 67, Lordship. Lordship, got to page 67,
Yes,
Lordship.
yes.
Lordship, kindly see para 7. Before amendment, 122 was officers and servants of the Gram Sashan. That is not a new post, that was their Lordship. They amended, they brought it, Lordship, executive officer of the Gram Sashan. Lordship, straight away come to the clause 2, the amended act. For the relevant time, because there is no adequate employees, adequate staffs of the Gram Panchayat, only to implement the amendment, Lordship, what is the, Lordship, kindly the government, what did, Lordship? The BLWs and BAWs working in the district shall for the purpose of section 1 act as executive officers within the local area of such grammars as may be respectively to be assigned to them by the collector. So because at the relevant time the collector was the appointing authority, and because there is no adequate employees, that's why, Lordship, the BLWs and working in the Gram Panchayat were deputed to work as executive officer. Lordship, kindly see, this amendment was made in 2004. Now it 2023. After 7th amendment, Lordship, after 30 years, this government come up with this amendment. And for the first time, the government has come up the rules, that is Panchayat executive officer appointment rules. So my preliminary submission, Lordship, before Lordship, it is they have come up with a fair rules who is for the employees of the Gram Panchayat. It cannot be, Lordship, kindly see that part is also tested by this Honorable Court in this judgment. Lordship, kindly come to page 73. Page 73, Lordship, same judgment, page 73. While declaring the such provision as ultra-virus, Lordship, page 73.
Yes, yes.
Lordship, reading from the top, Lordship, but the further logic of the state that BAW and BLWs remaining in the dual charge are to remain under the specific control and supervision of the director, collectors, and district panchayat officers, as stated above, is unacceptable in as much as if the executive officers of the panchayats who have bestowed with all the responsibilities relating to the maintenance of records, registers, and cash be kept under the control of the bureaucrats relating to their service conditions and functions, then the panchayats cannot function with independence, and that is how it would interfere with the constitutional mandates of self-government. So the very thing already been examined. This is the contemptuous, Lordship. My senior advisor should protect the law, not to the officers who has come up with this law. Lordship, kindly see this very same question was raised before this Honorable Court regarding interference and how to the curtailing the power of the Gram Panchayat. That's why this provision has been quashed.
Why don't we get what is the duties and responsibilities of the Panchayat executive officer?
Lordship, the statute says, Lordship.
What the statute says?
Statute says, Lordship, I'm reading Lordship 122.
Yes.
Lordship.
Do you have the copy of the compilation of Learned Advocate General?
Just now I got Lordship. Just now I got Lordship. Lordship, it is one constitutional crisis. Now, number of applications filed by the Gram Panchayats. Different sarpanchs have come up. Gram Panchayat have come up. This is a constitutional crisis. The government want to take over the entire administration. Lordship, there is no independence of the Gram Panchayat by virtue of this amendment, Lordship. Lordship, I'm reading 122, Lordship.
Yes, yes.
Every Gram Sashan, Milord, this is amended provision. Yes. There shall be a Panchayat executive officer to be appointed by the collector.
Yes.
Lordship, it is itself, Lordship, this amendment is contrary to the Lordship judgment of this Honorable Court. Cannot be collector, Lordship. Milord, because at the relevant time.
No, question is all the provisions.
Lordship.
Subsection 1, subsection 2, subsection 3
Lordship.
were challenged. And only the subsection 3 has been struck down.
Lordship, absolutely correct. But the Lordship, can the findings of the Honorable Court? Your Lordship has justified. Lordship, again, I'm reading Lordship.
Yes.
Lordship has never believed, Lordship supported the contents of the state government that the person cannot be dual charge. A person working under the state government cannot work under the Gram Panchayat because there, Lordship, can see the very language of this judgment. It's very clear, Lordship. Again, I'm reading cost of repetition. I'm reading, Lordship.
Yes. But you have thrown no
Page
challenge against the
73,
section again. Because this section was tested and it was held, it is constitutional. The
In fact,
problem-
in fact, Lordship, in fact, section 3, Lordship, can they have
Only out of the generally the 122 was challenged on the ground of the autonomy. All right.
Lordship.
But this court only struck down the subsection
That's
3.
absolutely correct. Absolutely correct, Lordship. I have
So
not done
other
that.
2 has been declared as constitutionally valid.
Lordship, I am not on that, Lordship. I am on the understanding and the conduct of the state, Lordship. What they are doing, Lordship, kindly see.
State is doing immoral act.
No, Lordship.
For that I cannot strike down the law.
No, I'm not on that, Lordship. Lordship, kindly see. What they are doing. They are, Lordship, kindly see that the language they have employed. They are not coming up with a new rules. In the name of, Lordship, repealing a VLW and VLW recruitment rules. They have inserted this post of Panchayat execution in the new rules. It is not independent.
Earlier rules was also framed under proviso to this.
309. Yes, Lordship, because that was a post under the state government.
Yes.
But now they have come up with, Lordship, had it been a case, Lordship, kindly see that.
No, they clearly it state is a cadre of the state government.
Had it been VLW, we have nothing to say.
This present post also it is a state government cadre.
Never, Lordship, cannot be. Lordship, cannot be. My humble submission before Lordship, it cannot be my understanding, Lordship, because Lordship, kindly see, it is born out from a constitutional provision, Lordship. Article 243G gives power to the state government to make rules and to give independence to the Gram Panchayat. That's why they have come up with the rules.
That is why you come to this provision, the duties and responsibilities of the Gram Panchayat executive officer.
Lordship, I'm reading again.
Their role has been also under this section 122. Just read subsection 2.
122, Lordship, I'm sitting 122. Remain in custody of all records, documents, cash, and valuable securities belonging or vested or under the direction of the management of the Gram Sassan as may be prescribed. So when I'm working under the Gram Panchayat, I will be under the control of Gram Panchayat, can be appointed by the collector and my controlling authority will be collector, Lordship. Is not.
When this court has declared these 2 provisions are constitutionally valid and there is no challenge, how can you argue against the statutory provision?
In fact, Lordship, that is under challenge also. Now, people has come up, Lordship, the Gram Panchayat come
We are
up.
concerned about these 2 writ petitions.
That's true, Lordship. But Lordship will tomorrow test this provision, this law.
You can build up a new argument.
Lordship, but my humble submission before Lordship, it is complete hijacking the entire Lordship. Lordship, what they are doing? Lordship,
I understand.
Lordship,
I understand.
Lordship, kindly see what they are doing. Lordship, kindly see. Again, come Lordship.
But these arguments have been rejected by this court.
Lordship, kindly come to Annex 3. I'm saying, submitting before Lordship about competence of the state government. Can they, Lordship, come up with a power which will contrary to the law, Lordship? Will contrary to the constitutional provisions?
Why? We are seeing that they have taken the power from section 122.
Lordship.
Section 122 provides them appoint to this executive officer. And now how the appointment will be made, they clearly provided in the new rule. Who will be the appointing authority? What is the nature?
But Lordship, that is there, but Lordship, kindly come to Annex 3 for a moment, Lordship. I don't have
Annex 3.
Lordship, Annex 3. Because the VLW and the VL rules, Lordship.
There is notification 11/12/2008.
Lordship.
We have read this notification.
I read it. Cost of repetition, I'm bringing Lordship's kind attention. Lordship, kindly see. Here, Lordship, they have come up with the amendment. Lordship, in supersession of the old rules that is 1994 rules. And Lordship, kindly see the definition. In that amendment also, there is a post of Gram Panchayat secretary. Means secretary appointed by the Gram Panchayat as per the provision under rules 1968.
Yes.
So earlier they have taken care to section 122 and 122, Lordship. So that's why, Lordship, to upgrade to cadre secretaries, they come up with the amendment of rules, VLW recruitment rules. And by virtue of this amendment, they gave promotion to the Panchayat secretaries. At the relevant time, they did not come up with a new rules that creating a post of Panchayat executive officer and to give appointment by the state government to the Panchayat executive officers. Now, Lordship, kindly what they have done, the present rules is not independent rule. What Lordship, kindly see Annex 10.
Yes.
Now they have come up with these rules. in supersession of the Odisha Village Level Workers Recruitment and Conditions Service Rules 2008. This is not an independent rules. Lordship, what am I back to submit before Lordship? Either 309
No,
or
according to your submission, Mr. Doloi, that 2008 rules
Lordship.
was also a rule for the government officer.
Right. Grateful Lordship.
And you wanted a migration through the 30% quota when there will be no proper availability of the eligible candidates?
For the time being,
no, just wait.
Lordship.
You find it constitutionally valid?
Lordship, for the time being, I am not going to that part, Lordship.
No, you have to go.
I will go, Lordship. I will
Yes,
travel.
You have to go
just-
because a
Lordship.
similar pattern has been followed in this framing of these
Lordship,
rules also.
Lordship, after completion of this argument, Lordship, so for the validity of the statute, then I will travel to that side, Lordship. I will answer, Lordship. Because what right I have acted in these rules, I will satisfy, Lordship. But now I am the question of the validity of the statute, Lordship.
Yes.
So that's why I'm saying, Lordship, that is a complete separate argument that definitely I will address Lordship on that. But my humble submission before Lordship on this part, Lordship, because this is a supersession of the old rules, that is VLW and VL Recruitment Rules 2008. It cannot be changed the nomenclature by Lordship, by way of encroachment to a provision under the Gram Panchayat Act. My humble Lordship, kindly consider Lordship, one aspect, Lordship. Had it been a case, they have ample power to come up amended these rules under section 309. Under Article 3 proviso.
If I rephrase your submission in this way, by you framing these rules under 309,
Lordship.
They wanted to sort of create a cadre to serve the purpose of the section 122 subsection 1.
Lordship.
How do you respond to that?
Lordship, my humble submission.
Because under section 122, if you read with section 123, it becomes clear there is two sets of officers. They will be working under the panchayat. One, those will be appointed exclusively by the panchayat to serve the interest of the panchayat, and there will be their salaries and wages will be reimbursed from the panchayat's own fund. And another set that is under section 122, the set of officers who will be the government officers, and they will serve a part of the function in the panchayat. What the duties and responsibilities is provided under subsection 2. What they will do? If you are agreed by the subsection 2, that is where you are saying the state government is trying to encroach upon the autonomy of the panchayat, the self-government principle, then you had to challenge this subsection 1 and 2 both.
But my humble submission for Lordship.
No, just wait. If this subsection 1 says this is the cadre of the government, and government will pay their allowances, appointing authority of this thing, and they will discharge the following responsibility. They will sit in the meeting of the panchayat, they record the minutes of the meeting, they will custodian of the records. Try to understand me. If this offends the principle of autonomy under a self-government body like panchayat, that your principal challenge would be the source of the power that government have taken from under section 122, subsection 1 and 2 to challenge their constitutional validity. And that was challenged in this court. Court held these are constitutionally valid. Only subsection 3 is not constitutionally valid. It was struck down.
So my simple submission.
No, if the source is provided to the government by the statute, unless the source is attacked, that the source is constitutionally not valid,
Lordship, kindly.
How can you stop the government?
No,
from exercising?
I'm never stopping the government, Lordship. Article 243G gives enough power to the state government to come up with the rules. I am not on that. I am on the Article 243G. That's why the state government, because it is enabling provision, they have come up with the rules. They have come up with section 150. They have amended that, and they should have come. Let's the same power.
Mr. Doloi, when the issue is of the challenging a rule or the provisions of the Act is concerned, the obiter dicta doesn't have a place in understanding these provisions of the law. Court may say so many things. It ought to have been the ideal situation if the government is no manner interference in the functioning of the panchayat. Just wait.
Lordship.
But this will not impact when the challenge is against a particular provision of the Act.
Lordship, in fact, I am praying for interference of the state government, but in accordance with law. Lordship, kindly consider one aspect.
Yes.
Lordship, Article 243 gives them enough power to come up with the rules.
Exactly.
Accordingly, they have amended the Gram Panchayat Act and the brought up section 150. The government has enough power to come up with the rules. had it been a case, they are going to give appointment the Panchayat executive officers.
No, 150 is the rules under that act.
No, Lordship, they should have come out with section 100 exercise of section 150 and to create a post on the Gram Panchayat. There may be to enter funds and appointment may be by the collector. But they should not resort the article 309 proviso. If it's coming 309 proviso.
They solidly on the ground that these are my officer. I will regulate the service condition under.
It cannot be, Lordship.
Why? That is what I need to understand from you.
Lordship.
Why that cannot be?
Because that will be amounts to interference of the Gram Panchayat. Article 240 will be affected, Lordship. It will be automatically, Lordship, kindly consider if an officer of the state
That
government.
was the same set of argument was placed before the court, which was
That's why
examining
the
validity of section 122.
But Lordship, kindly see the observation. Court has disbelieved. Court has, Lordship, negated the entire contention. Court has said it cannot be.
But the court did not this strike down the two provisions, subsection 1 and 2.
Now before Lordship, because we are before Lordship, because taking advantage of that, Lordship, kindly see, because it could have been, because this now Lordship reading the amended statute, because they should understand the verdicts of the court. Court, while declaring section 3 coronavirus, court has given finding also.
Now you are placing the arguments on morality of the governments. Like
Lordship,
what they should have done and they should not have done.
No, Lordship, what I am, in fact, Lordship, kindly, I am relying the your Lordship judgment because your Lordship kindly, so while declaring ultra virus 1 section 122(3), your Lordship is given very clear findings that a person working under the state government or under the collector cannot act under the Gram Panchayat. It will amount to enter the Gram Panchayat. Because Lordship kindly say that page 73, kindly read, I'm requesting Lordship kindly again come to only 3 or 4 lines. Because the Lordship is given the resolution, they can ignore.
Page 73 of
Page 73 of my compilation, Lordship.
Okay.
What might have been first 1 3, page
Problem
73.
is that if there is an obiter and there is no direction upon the government, they will create two situations. What is the page
Lordship,
number?
what they have done?
73 again.
73, Lordship, again. But the function, further logic of the state government, Lordship, state that VAWs and BLWs remaining in the dual charge are the remain under the specific control and supervision of the director, collectors, and district panchayat officers as stated above is unacceptable in as much. If the executive officers of the panchayats who have been bestowed with all responsibilities relating to the maintenance of records, registers, and cash and be kept under control of the bureaucrats relating to their service conditions and function, then panchayats cannot function with independence, and that is how that would interfere with the constitutional mandates of the self-government. For the reasons assigned by the state in VLWs are to function as executive officers in their duties and responsibilities with respect to the duties of panchayat, and their services should be within control of the Gram Panchayats, or else Gram Panchayats may suffer from any discipline or refusal or negligence to carry out the lawful order of the Sarpanch or Panchayat, as the case may be, apart from their make class a priority to carry out specific orders issued by 2 authorities, Panchayats and states. So the findings is very clear, Lordship. The government should understand the verdicts of the court. Very sorry state of they are not understanding the verdicts of the court, Lordship. Knowing fully well, they have come up with the amendment. Then also they are saying collector will be appointing authority. And they will exercise the entire 6,000 Gram Panchayats by the whims of the collector, Lordship.
Come also to the paragraph 18 after discussing all these things. Just see what is the observation has been made.
Lordship, after that, Lordship, so Lordship, they should read the judgment as a whole, Lordship. Lordship, while coming, but because Lordship, after that, Lordship, they have come up with the amendment.
By you have reading they cannot come to a conclusion that these section 122(1) and section 122(2) is unconstitutional. They cannot come to a conclusion. It is the court's duty to come to that conclusion.
No, Lordship, they have come up with the amendment because after reading the entire judgment and after in consonance the judgment, they have come up with the amendment. Still, they have kept the collector as the appointing authority. Lordship, that is the sorry state of affairs, Lordship, because they should understand because they enter judgment, Lordship, because there's the relevant time, perhaps the prayer must be to declare the 122(3) is unconstitutional. That's why, Lordship, pass the order. But at the same time, Lordship, given a detailed complete and very Lordship, understandable judgment, Lordship. There is no hesitation to understand the verdicts of the court, Lordship. Lordship, my simple Lordship prayer would be, can Lordship, in view of the Article 243G, can this Lordship rules will survive, Lordship, if they will control the entire Gram Panchayat by the whims of the collector? The collector will be the discipline authority, collector will be the appointing authority, every collector, and they will work under the Gram Panchayat.
No, nothing of that sort is happening under this section 122.
But these rules, they have come for first time, Lordship.
No,
Now,
what is the duties and responsibilities of the Panchayat executive officer is clearly laid down under subsection 2 of section 122.
That's true, Lordship. Now, and
you have no difficulty with that rule.
Now, my virtue of these rules, Lordship, they have taken over the entire administration. Lordship, can come the rules. What they have done? They have, after this amendment, this was, Lordship, somehow, Lordship, it was continuing with a great fairness, Lordship. But by of this amendment, now the entire control will go to the bureaucrats, Lordship. Lordship, kindly see, they have not whispered a single language of Gram Panchayat. Lordship, kindly come to the Annex 10, the rules. Though they are giving appointment to Panchayat executive officers, they have not whispered a single word about Gram Panchayat. Had it been a single word, then I have no guess, Lordship. Lordship, see the intention of the state government.
Can court direct that a particular rule, particular provision of the act should be amended in a particular manner?
My humble submission to quash the entire order, to declare enter the rules, Lordship, ultra virus. But Lordship, I am not, just I am pointing, Lordship,
No, because
what manner they have done this, Lordship.
Mr. Dolo, you must be fair to the court that there is no challenge against section 122.
That's true, Lordship. But now they have come, Lordship. They have come up, Lordship. Already they have filed, perhaps tomorrow, day after tomorrow, Lordship, take up all those matters. Because it is, Lordship, completely, Lordship have already had in length, Lordship. So definitely it will be. Lordship.
No, we are concerned presently with these two writ petitions. If the similar challenges on a different premises come up, definitely we have a duty as a constitutional court to look into whether this act or rules is according to the constitutional scheme or not. We are bound, duty bound to examine.
Lordship.
But with the present case, there is no challenge against 122.
122, that is not under challenge, Lordship.
And if there is no under challenge, this we have to presume the constitutionality of the subsection 1 and subsection 2 of section 122.
But my humble people, Lordship, definitely we have made a submission there that it should be very.
No, you are arguing entirely on the constitutional morality.
No, Lordship. Why, Lordship, it should be clarified. It is a post under the state government and there is no control of the Gram Panchayat. So definitely, Lordship, if government will give thousands of appointments, the Gram Panchayat nothing to say. Prior to this rules also, they are giving appointment to VLOC, VLW, still Panchayats are working.
And Mr. Dolo, that there is an old debate. What is the distinction between the self-governance and the distinction between the autonomous entity of a body? Panchayat was never thought of as an autonomous body. It was a self-government.
Self-government, Lordship.
And there is always a syncretic relationship with the government.
That's true,
how the control is exercised, it is an arrangement that is been made. In everything, you have the urban body, the municipal corporation, you go to the all acts available in the country. There is a syncretic relation with the administration.
Lordship, I don't.
That is the reason why the urban development departments in every state government has been created.
Cases when a person is working under Gram Panchayat, even no collector, even if secretary, Panchayat secretary has no power to interfere with take any action against them. But I am not on that, Lordship. I am saying, Lordship, because Lordship can say these Panchayat executive officers. Earlier, Lordship, VLW, apart from this post, Lordship, Panchayat executive, there are other posts, those who are assisting Gram Panchayat. Lordship, for example, Lordship, the junior engineer, assistant engineer, the BDO, the sub-collector, they are direct employees of the state government. They are working under the state government. Also, they are supervising and assisting the Gram Panchayat for development works. But here is a post, Lordship, it has been created under the statute.
Yes, that is the question.
So, Lordship, there cannot be controlled by the state government. There should not be control of the state government either to give appointment or to take any supervisory action on the Gram Panchayat by throwing.
Read subsection 2. What their power has been granted under subsection 2, they cannot go beyond that.
That is, Lordship, that's why when Odisha, Lordship, their officers so clever, they amend statute in such a manner,
it will take time. Our panchayats will understand and they will come to before lordship. It is lordship, ground reality lordship. So that's why they are ruling over the state lordship. Then lordship, then I'll come to the second part lordship. Second submission lordship, kindly see.
This is a highly political statement. You have nothing to do.
In fact, lordship, we are in a position. Lordship, I am coming to the second part of submission, lordship.
That is the advantage on being this side. You can say anything you want.
In fact, lordship, I was expecting when my seniors are appearing, my work will be
No, we are
easy
grateful
and
that advocate general is taking time out to that come to this.
lordship,
court.
I'm grateful, lordship, because lordship, the second part of lordship can consider. Lordship, I have in this case, I have given a lordship's judgment also, lordship. Earlier, I had come before lordship regarding regularization of this Gram Rodga Sevaks.
This is the second part of your release.
Second part of it. I'm coming to second part, lordship, because I have. Lordship, kindly see, this is a post they have been appointed by a central statute, that is MG NRJS Act 2005, lordship. And lordship, I have done a lordship's kind attention to Annexure 1.
And when you are arguing this matter, this para 10 of this P.U. Joshi's case, you must take into consideration. This is a declaration of law by the Supreme Court.
Lord.
Earlier position, I'm telling you, the
Lordship.
old rules and even the vacancies created during the time of the operation of the old rules, Supreme Court was very consistent that you will be guided by the old rules filling about the old vacancies which was created. Now they have taken a paradigm shift. They have taken a uniform policy. The rule is a rule, operation start. The vacancies are not important thing to decide the area of operation of a particular rule.
I will not argue that, lordship. I'm quite conscious.
If you say that you go by this decision, perhaps you have no case. So for the second part of the release is
So
concerned.
for second part is concerned, lordship, there is some arbitrary decision. That's why just because your lordship is given a judgment, lordship kindly say perhaps I have given in my miscase, your lordship judgment is there. Your lordship has given a direction to the state government to consider the case of this Gram Rodga Sevaks, lordship. Because earlier those 2008 amendment was under challenge, because we are opposing to the reservation of 30%, we are claiming 100% because we are also working as like
we have left the issue for the consideration of the state government. Whether any welfare scheme can be formulated for them.
But so my humble son, it is not a welfare scheme. Now what they have come by of this bringing up these rules, well, also kind of one provision, lordship, what they have done.
Again, you are coming on the doctrine of the legislative competence, and para 10 of this Justice Raju's judgment is very categorical over that issue.
But my humble submission, because your lordship has given a judgment to them.
No, that is for consideration of the state government for a welfare scheme for these people. Because I am you are talking about the persons who have not crossed 45 years.
Lordship.
Right. Though, what about those persons who have crossed the 45 years after serving the long time?
I am on, in fact, lordship, I will come to that because we are also saying, because you are dividing a particular group of people. This is violation of Article 14 because you gave benefit us.
No, that is the problem. They are not the equals. State government is creating the eligibility criteria for the appointment. And that is why the para 10 of the Justice Raju's judgment is very important. When they are determining the criteria for the eligibility, state government has to take so many factors in consideration, including the financial factors. But the welfare schemes doesn't mean that should be given these, this is the only benefit of regularization. Now the central government has come with a scheme, most of the state government are not accepting it for the Anganwadi workers. Earlier their maximum year of engagement was up to 60 years. Central government is trying to impress all the state government, raise it up to the year of the 65 years. Even in a judgment, Justice Qureshi has written a judgment in Tripura High Court. Says what you lose, why you are not giving. Right?
Yes.
But the decision has been interfered by a same division bench says, who are we to talk about this? Because of the same, the policy domain is exclusively occupied by the
state government,
the state of the central government.
Lawmaking.
So this judgment you are referring to, I know you will refer to the judgment earlier also for an interim order. You can. This is a direction for considering whether any welfare scheme for purpose of bringing them in the regular establishment or give certain other benefits can be given. We have left that issue for determination by the state government. Can we give any direction? That is the fundamental question that we are faced with.
I'll try my best to develop
No, we are
arguments in next case,
definitely,
Lordship, because Gram Panchayats are coming.
Definitely, you argue that.
Lordship, no, Lordship, next case I'm saying, Lordship.
We are
because-
just, what is that traveling through our minds, you're loudly just speaking out so that you can understand
Lordship.
that the issues that might come in your way also in deciding and determining the challenge that you have made. Can you complete it for another 15 minutes? You sit by
No,
extension of
Lordship,
time.
I will not.
No, I am not.
I'll not give pain, Lordship, because
I am not tired.
No, in fact, Lordship, only my humble submission, I'll develop my argument in next cases, Lordship, because other cases are
So you have
definitely.
completed. So for this case is
This
concerned.
case is concerned, Lordship, nothing to say, Lordship. If Lordship, Huh?
In the second case also, you
My
are
friend, senior friend saying, can I do tomorrow for 15 minutes, you will address if necessary. And
you are in the second
second case, Lordship.
Okay. 15 minutes.
Just for 15 minutes, Lordship. I will take 5 minutes.
Can you just complete today?
Lords, my learned AG has not supplied me the compilations judgments. That I will check up whether.
All
these
right.
are-
Take this compilation. I am giving my compilation given by AG to me.
I'll give them, Your Lordship. I'll give myself.
Only 10 to 15 minutes.
Today?
Tomorrow.
Why tomorrow?
Because I will check up, then I will answer. Well, also covered up all the issues. Then some facts which I want to bring to Lordship's notice for my own satisfaction, because my client may not blame me that these points could not be raised before Lordship. Therefore, I will bring to Lordship's notice. And I have, as I have observed, Lordship,
is this
all
possible
parts have
tomorrow?
covered.
Huh?
I undertake only 15 minutes, nothing more, nothing less. I will complete it tomorrow.
I think it is not the lawyer's 15 minutes. Tomorrow come at 3:30. Learned advocate general here. Because at 2:30, there is another part of matter.
Yes,
Deeply obliged.
deeply.
Just take the justice. We have heard Mr. First case, learned counsel for the petitioner. Learned counsel for the petitioner. And also Mr. A. Parijal and Advocate General appearing for the state opposite parties. We give the learned counsel Mr. Dolui, SK Dolui. Stop. The hearing is complete. So far, this writ petition is concerned. But we could not hear the learned counsel, Mr. Sachin Search, for the other writ petition for shortage of time. For that reason, this matter will be also listed on such and such date tomorrow at 3:30, along with the analogous writ petition being WPC number such and such. In the said petition, in view of the order passed today, this writ petition will be taken up for hearing on such and such date at 3:30. Stop. As parted. That is also only this case as parted. Others we have decided this is hard fully. Only the next case will be treated as a parted.
My lord.
And there also you have made your submission from both
My-
the cases. We only hear the counsel of the
Lordship.
petitioner.
My lord, item number 45, my lord. It is a PIL regarding appointment of members of the State Commission for Protection of Child Rights.
There is
It
no
was
commission.
State Commission for Protection
There
of
is no
Child.
state commission.
There is a state commission, but out of 6 members, only after intervention of the court, only 3 members have been appointed. Then time was given today for the rest of
Already
members.
what
to be-
My lord, I am appealing for the state. In that case, today we have filed a petition seeking 2 months' time because we have already filled up 3 posts. For rest balance 3 posts, we need.
Well, good proposal. We are disposing the matter. Within 2 months, you fill up the order.
Lordship is.
My lord, let it not be disposed of. Let a date after 2 months may be fixed.
Huh?
It may be
No,
recorded.
no. You come with this violation, if our order is not obeyed, we are disposing the matter. This is coming with a very fair proposition that within 2 months they will be complete the filling up of the other vacancies. What is your interest? You cannot have any interest because
No,
we will
no,
be
no
selected in
personal
the
interest.
domain
Filling
of the
up of-
governance.
time may be fixed, my lord, yes.
Yes, 2 months' time, they are proposing, I will give granting them 2 months'
That
time.
IA is not
I'm
on
obliged.
record because I have filed it in the registry, your lordship.
Not necessary. we'll
No, you're
discuss
wanting
ordinary.
2 months' time on a oral submission, we'll grant you.
Yes.
It is under process. Appointment
Yeah,
is under
it is on
process.
process.
Very good.
Already 3 posts are filled up.
Yes,
Only-
that's what he's saying. For the other 3, he's saying.
Obliged.
Just we are passing the order, is a short order, we are passing it.
This is item 40.
45 item.
45.
Item 45.
By means of this public interest litigation, the petitioner has asked this court for directing the state government calling upon the directly calling upon the state government to constitute the
No, to appoint 3 members.
just a minute. Orissa State Commission for Protection of Child Rights by filling up the vacancies in conformity with the section 17 and 18 of the Commissions for Protection of Child Rights Act 2005. Is your order?
21, please.
No, this is here. By the order dated 21/3/2023, this court had observed that partly the state commission has been constituted, keeping the 3 posts vacants. Prabir Kumar Das, the petitioner in his person, has submitted that the state government has not filled up those vacancies till now. And such action of this state government is in contrast to the Rule 6(6) of the Orissa State Child
Protection Commission.
Orissa State
Commission.
Commission for Protection of Child Rights Rules 2009. So, whenever vacancy is there, either by way of death, resignation, or for any other reason, the state government is bound under the said rules to fill up the vacancy within 180 days from the date of occurrence of such vacancy. Stop. True, it is that the vacancy has not been filled up as per the mandate of the said rule. But Mr. D.K. Mohanty, learned additional government advocate, has assured this court the commission will be fully constituted within a period of 2 months by filling up.
One interim application has also been filed by the government. IA has also been filed by the government seeking 2 months' time to comply the.
So within 2 months' time. In this regard, an interlocutory application has also been filed seeking the extension of time by 2 months. So that the commission can be constituted fully. Stop. Having situated thus, we direct the state government to fully constitute the commission by filling up the remaining 3 vacancies within a period of 2 months from today. Without fail. Stop. In terms of the above, this public interest litigation stands allowed and disposed of.
May I pray one thing? Lordship may direct to communicate this order to the Secretary WNCD. This order may be communicated to the WNCD department.
Why?
Free copy.
Oh, free copy.
Yes, ma'am.
Yes. A copy of this order be supplied to the council, Mr. D.K. Mohanty, as well as to the petitioner, free of cost. All right.
Obliged.